Yes. Uh, this next Friday. Today, we have some difficulty today, may not be today, by tomorrow. Tomorrow. Anyhow, somehow you manage with tomorrow. 44. 44. Additional affidavit. We are calling. Yes. You have already filed or are going to file? If matter reach, we won't, won't file, accordingly order will be passed. So if it has already been filed, we are marking it. It's a bail hearing column. Okay then. 33. Yes. You were on interim. CD not received, you're saying? Yes, Sharma. Should remind them, updated case CD we call for. Yes, Sharma, when it can be listed. No, she's on interim. Try to give a date because we are busy this week. Pardon? Okay. 29, eh? What is the position of 23? You are on interim. CD not received, issue reminder. Yes. Oh, you are for the respondent here. Oh, it is of 24, na? Oh, come on, let it be a bit in the month of August only. Let interim be extended. 37. Here also, Sharma, CD not available. CD not received. Should remind. Yes. 29. Interim be extended. 40. Yes. CD not received here. Victim is. Acha, interim is not here. Oh. CD not received. Should remind not on interim. Right. 20. 20 you are saying? Yes. 2020. Acha, yes. What do you think? Record may be called for, matter may be fixed at 2. I couldn't. We'll check it. We are, cannot for your from your submission we cannot pick. That is it. Whenever the case record reaches, we'll see it. Yes. We are not in a position to fix it. I don't know whether it is received or they will take the information, then only it will be. Yes, it's not present. But 42 and 31. 31, yes. What is the position? CD received already. Huh? Medical emergency. CD received, no? CD received at a request made by so and so. CD case is adjourned. CD received. Retain the case diary till next date of listing. Yes. Because you are going to retain the case diary, I think. 11, 12, lot more cases are 11, 12, 13. Most of the cases are. Maybe on 14 also, I don't know. We retain the case diary for. No, you have to retain the case diary. Yes. CD may be written, I think. Okay. Or if you want any long date, then you are on interim. Then you can return back the case diary. Yes, when then it can be 2939. No, give a longer date then. If you're going to return, it may not reach out. 4th of September. 4th of September, go to CDB return, call for the update. Interim was there, interim we continue doing it. Yes, well. And another matter? Yes, 42. Here also your interim. Interim be extended, CD not received, this will remind. Second. Oh, 7. Already been arrested. 7. You are MS Singh, J Singh. J Singh, Dilane Council of Petition. P. Sharma, Dilane Petition. On behalf of state respondent. It is submitted by Mr. MS Singh that the petitioner already got arrested in connection with this case, and accordingly, the present petition is become infectious. In view of this, the matter is accordingly dispersed on being rendered infectious. Okay, it will be dispersed. Yes. You are interim. We did not receive. Same 49 can be 49. Be extended till next list. 40, 41. No. What you one is already petition number 1 arrested, and 2. No, we'll see to it on the if the request. It's CD received here. Record. No, we have to go for the record. And you're saying that one was on not on interim. Two was on interim. Already arrested. And we can pass the order on date fix then. Why you are going to second? Interim. Otherwise, interim is for 2 only, na? City not received. So reminder, interim extended to the petition number 2 be granted to the petition number 2 be extended till next date of list accordingly. Yes. When it can be. 22nd of August. We have to take out the record. You have to wait for your turn then, because this is long order, na? That's why. Otherwise, also no difference will make if he already arrested. Suppose obviously will 22nd will pass the order regarding his the matter become infructuous on part of the petition number 1, but 2 are on interim. 2 was on interim, so we extended his interim. Then you wait for your turn. Wait for it. Whenever it matter will be. What? Friday? Which one? Actually, Friday is first. Okay. Okay. আটটাকে কোনো করিব দেই আটটাকে কোনো করিব
It is, yeah,
এই রিপার কি করবো না দুটা করবো। Friday, you know, মই কৈছো ফৰ্মেল আৰু এজনক সেট আপটো তালৈকে আনিব আপুনি regarding this changes na so we are facing some any connectivity and all everything is had to be changed na so yesterday also they were come morning hours they have come walking since 9 sorry after that is the problem anyway yes Mr. So your item number 1 na yes
The FIR. So uh, it, it, how FIR is high. Yeah, or they are for this one and they are they are they are detailed for they now
Mr. Abdullah is in for informant. Something would have been.
the information already like yeah. Otherwise, if you want their update, yeah, I did it. It is my it is
It's obvious, he is not filing any, he is assisting only. No, obvious. It's not a case of POXO, but he is assisting only.
that's why that's why I
Okay, anyway, let's see, obviously he is submitting one thing that for dacoity, it is for dacoity is minimum 5% is required, and here 3. But we are not in a position undoubtedly to say as to whether was there any other person, but namely 3 persons were there. May not attract this base, but otherwise there may be other sections also. So let us build the CD, case diary. So short date in a sense, past 9 days. I thought nearly good. Short date, we have some problem in fact. For short date, we have some problem. 8, we are not fixing any 8. Most probably, we are leaving for this Orunachal.
He was
So he has come for ring ceremony. What purpose they went to at around more than after 1:30 at night or AM? What for purpose? No, as per FIR, I'm not on the otherwise. There may be false allegations. So false allegation may be there. I don't know, but what was the purpose of knowing? Anyway, we're listing it on somehow he has given one date only 6/8 of this month. We're calling for the case. CDP call for 6. Yes, 6.
Step two,
No, that is the allegation. Midday meal, except for the midday meal is the allegation. There wasn't some anomalies or something was done by some other teachers, but she was been harassed and definitely she. Anyway, your petitioner is in custody since 6/7. 20 days is in custody. We'll try, but we don't have any date anyway. देखिए, आपको जो provide बन गया, देखिए, provide, हाँ? He's saying that We don't have any date, but yes, for your condition, considering we are giving on fourth of this month.
Item to be.
Otherwise, he is in custody since when? 7. Except if we don't have. I can understand your problem, but huh? 7. 7. Pero needy. ইয়াতে ক'লে ইয়াতে দি দিয়া। Yes. At 2. At 2. FIR. Hmm. Anyway, it is a case of 30, I mean, murder case. Murder case interim is cannot be a case. Obviously, we'll peruse the case there, we'll see to it. The FIR named accused, an allegation is that he was assaulted very brutally and got co-accused. But we are not in a position. Maybe by coordinate bench, or you can withdraw and 301 matter, later you are the FIR named accused and the directly allegation against you that you assaulted very badly to the person and for which he died. So how can it's a case of interim? It cannot be a case of interim. Not at all. We are not in a position to say anything now. FIR is there. In FIR, you are the FIR named accused, and FIR it stated that you all together assaulted the petitioner. But how can we say whether your involvement is how much is your involvement? That's why I'm saying CD may review. You may be there, you may not assault also. That part you have not may not take. I mean, you may not take any active role in that case. But at this stage, it's not possible. Coordinate bench may have some reason. That is why their names were there. Maybe, maybe. Yes, one can be called. We're calling for the case diary. Let us see the case diary. If it is not at all anything, definitely it will be a case for. Okay. কোনটো আমি এটা কোনটো 5 খন আছে ওকে ও বেল হিয়াৰিং কিয় আনে মোচন বিলাক একে মোচন ডেট
6.
Everyone here, that is. Yeah, but at least, yeah, yeah, they're trying to encourage people that holding down the public has lost there. And it's, uh,
Earlier he was working as a
For the
why he resigned? Complaint.
there's something there that I don't know, but yes, it's because
Cannot also.
it's and yet
Pardon?
everything.
Monthly papers forwarding report. Monthly papers forwarding you have not annexed here. No, whatever you have not annexed here. No? Done. Yes, you learn also. We shall fill an additional PP appearing on the state respondent. Then application students is submitted by Mr. Google at the presentation. Innocent is no. He is the person who he was working with the secretary in the state cooperative society, uh, and uh, subsequently he made a complaint before the assistant resident register cooperative society, regards to the anomalies and misappropriation of money by party president of the society, namely one Manjil Beg. On the basis of his complaint also, one inquiry was made by the committee, and wherein the said one Begu also admitted, and that admitted in regards to the misappropriation of huge amount of money. But the present petitioner received a notice under section 35(3) BNSS. However, he could not appear on the day when he was asked to appear and paid for time. Accordingly, he is asked to appear on 31st of uh, July, but he has the apprehension that he may be arrested in connection with this case, and hence the present petition has been filed seeking the privilege of rearrest. However, he is ready and willing to cooperate the IR. Mr. Sharma, the learned petitioner PP, raised objection and submitted that only CD will reveal his involvement in the alleged offense, and without proof of the case, it cannot be said as to whether the present petitioner is also involved in the case. Accordingly, he insisted to call for the he will be under interim protection. We have seen this, Sharma, this forwarding report. That's why I asked to see. This forwarding report was definitely for the accused Manjil Gogoi. But here is also, there's no note from the IO that regarding there may be some involvement of the other persons. It's silent. That's why I thought. Month. And I think that his complaint or his resignation may be one of the, yes, you're granting 7 days. 2/8. 2/8. আগে আধা যায় আধা আনি বেশি ঠান্ডা লাগে না ও এই তো কফি এগুলো গোটা এতে কেন চলা yes. Eight, nine, 8 is there. Repeat this.
I demand.
Name. One, two, four. So this is the anticipatory bail period for the case number 3, petition number 3. Yes. He is not the FIR name that. Is he FIR name? Yes, it is was subsequently rejected. Artist AMA did not consider also artist case Ilan additional PPA being the application and students. It is submitted to Mr. Ahmed Adil as an expeditioner sign. They have committed any such offense allegedly at petitioner number 1 is he is the brother-in-law, no? Also, brother of the uh, brother of the husband, brother-in-law of the deceased, and petitioner number 2 is the sister-in-law of the deceased, and the petitioner number 3 is brother-in-law of the accused number 1, that is the husband of the husband of the deceased. Accordingly submitted that these 3 petitioners are not at all involved with the alleged offense, and there is no specific allegations brought against these 3 petitioners in the FIR. Apart from that, the petition number 3 is also not an FIR named accused, FIR named accused. We further submitted that earlier a anticipatory bail petition was moved before the learned session judge, and he was granted with the interim period bail. Subsequently, on perusal of the case diary, the anticipatory bail prayer of the petitioner was rejected by the learned session judge. Only after the rejection of the bail, anticipatory bail petition, the IO issued a notice and section 35(3) BNS asking him to appear before the police station, and accordingly he has the apprehension of being arrested in connection with this case and connection with this case. However, all its petitioners are ready and willing to cooperate with IU in further investigation of this case if they are granted with some interim petition. Mr. Sutia, the learned additional PP submitted in this report that all the petitioners are, the CD will reveal the involvement of all the petitioners. And apart from that, the petition number 1 and 2 are also the FIR name used, and the petition number and the bail anticipatory bail clear, the petition number 3 was rejected by the London Session Judge only after the perusal of the case diary. Mr. Chair, accordingly, today's objection submitted that CD will reveal the actual fact of the case and interim pre-arrest bail term may not be considered at this stage. Thanks for hearing the submission made by learning counsel and both sides and other aspects of the case. The interim or prayer for interim pre-arrest bail for the petitioner number 1 and 2 is not considered at this stage. However, the prayer for interim bail for the petition number 3 however, the petition number 3 is provided with some interim protection till receipt of it. 3 will be under interim protection. 1 and 2, there is no interim protection. 1 and 2, there is no interim protection. 3 will be under interim protection. Again, that's where it can be. See, for 1 and 2, interim is not there. For 3, interim is there. Yes, CDC. For others, 12 feet. Where is the case number? Can you tell us? PA number? Therefore, along with PA number 2356 of non-FIR. Why do you have apprehension? Huh. She's a major lady. So even if she, leaving her matrimonial house, even if she is staying with the petitioner number 1, what is the harm? Why police will search? Is there any case of kidnapping and all? Kidnapping or what? No, you're saying that Bulbul or whatever number 2, she was a married wife of someone. And then due to torture and all, she had to leave her matrimonial house and now she is staying with the number 1. It's okay. So why case will be there? Whether your petition number 2 had lost any case? Or under what allegation? What was the news? It's a major woman kidnapping. It's called for a report. No protection. Yes, not a case. Against you, there may not be any case. Only 1 day shelter may be there. So what? Petitioner number 1 searching. Why petitioner number 2 is also searching? Why? Now where she is now? Where is he? Where where she is staying now at present? No, in whose place? And I mean in Dhubri receipt. His parents, her parents' house. Maybe she may be there. Anyway, we call for the report from Bogribari PS. You are Mr. Heard Mr. S. Hussain, the learned counsel for this and also heard Mr. J. Sutia, the learned additional PP, appearing on behalf of the call for a report from Bogribari PS, Bogribari PS of the Kokrajhar as to whether any case has been registered, any FIR oblique case has been registered against these two petitions, number 1 and 2. The additional PB will take necessary steps in intimating the IO and procuring the report from the concerned police station. IO no, from the OC, OC from the concerned police station. Yes, when it can be listed. First week. Court. Only report you call for. Court of. Ah. Right. FI is the page number 10. Hmm. CDB call for, of course. Otherwise, it is a case of 9 years. In a sense, it's not a case of 9 years. Since 2016, their matter was there, but the FIR is not so clear from when it was within the knowledge of so and so that this misappropriation or the extortion was going on. It is not clear from the FIR, but yes, 2016, since 2016, the matter was there. So let us see the case diary if it is anything is there. Now first, I don't know, first we have, and you can, okay, then first somehow we are giving on first. Another application. Okay, then now tell us what is the number? BA. BA is 2230 in that case also. 1842, then 25 CDB call for, and matter will be listed along with BA 2230 oblique. Okay. That's good. Yes. But your matric, you have a passed your matriculation matriculation to open school of finding. Matriculation certificate also can be obtained from the open school. Okay. Hard Mr. S. Nawaz, student concept petition. So hard Mr. J. Sutia, appearing on behalf of this is an application under Section 82 BNSS, paying for anticipatory bill with an apprehension of being arrested by OC 5 by the police of Murajhar Police Station, District Kolkata. It is submitted by Mr. Nawaz that the earlier complaint was lodged by whom? As apprehension and full stop. One allegation was made by one Safikur Rahman after his election in Panchayat, after he being elected in Panchayat election, alleging that his matriculation certificate is fake. But in that regard, he had already furnished his matriculation certificate, which he obtained, which he as he passed his matriculation matric he has passed his matric or the 10th standard from the open school. Expert this context, later report be called for as to whether any FIR of the case has been registered against the present petitioner in. No, that's why we have to inquiry, make an inquiry. So as to whether if, is there any FIR or oblique case is registered against the present petitioner under Murajhar PS District Panchayat. It is she, also as a she. Okay, let it be on 1st of August. You make an inquiry as to whether report may be called for from the Murajhar police station. Is there any case registered against? Okay. How does? One more year with you. আচ্ছা, fourth? No, first question. You want fourth? 1st of August we are giving. Okay, for timing we have.
12,
12, no, 30. Yes. 11. Hmm. That is fake. But if we put any question to that lady who won the panchayat election, will be she be can reply or can answer? I think she cannot reply any questions. Even if a simple GK, even if a simple English word, anything, she won't be able to. This is the case. Open school. She's not at all. I mean, maybe okay. This is the true fact. In fact, hmm? She doesn't know anything. I think practically she doesn't know anything. No ABCD, nothing. Somehow she obtained this certificate. Oh, wow. Oh, if she is so sharp, then why she is for open school only? Why? Why? Otherwise, she is meritorious. She is meritorious otherwise. That is obviously, it will be under investigation. ACB. What is this? ACD? No, there are some open school. We also know that KK Handy and something. There are open school, university open school. But from did she obtained it from Delhi open school. That's why let us see the case that CDB call. We are calling for the city. We'll try to give you a shorter report for party. May not be possible on this week, this next week. Maybe on 11th or 12th. Manage. It is AB only. We don't know the certificate himself is, I don't know whether these are genuine or not. This certificate have already collected by the IO, I think. Okay, will be under entry. 28-8. Appear before the IO. Simply Just a second, page 30. Oh, yeah. It also yeah, I don't know between the yeah, with report the 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 wait 288 you text it and there is intent prayer then to that report with with that what 50 oh 150 yes yes where we have received here yes that without you want it registered not under 109 but 103. Not suspicion, every material is against you. It's not a case of suspicion. Against you only the entire allegation is brought. Not on, may not be involved, I cannot say. PM report, he is on 81 days. So I think, I don't know, you, or you can make any communication whether the charge is dead because till now PM report could not be collected till date. Cause of death is not there, but what is the injury mark and all these things are there. Make a communication, yeah, tomorrow or when? So this is updated one, not taken back. Then we don't have, he is on 81 days in custody. Then how can you can will you be able to send it back, take it back? I don't call PM, not only PM report, you make an inquiry also in regards to filing of the charge sheet. Is there any preparation or it has already been filed or whatever? That only you can retain the case, right? Because he is an 81 day, uh, next they give charge sheet. He died. 20, 20, I think 20, both sides. They do May, first, July and August, till 31st or because 81 days is in 31st. You want to send it back? It will come by 31st. Updated GPA, GPA, and 85, 84, 85 days will be there. Make a try. Just city we are going to return from where it has to come. This food. Okay, we at 16 and 17. Yes, basically. Yes, yes. One Himanta Sakya and what about?
Your loss will see from the forwarding report in this page 70, the forwarding report is there, madam, in the next item.
In the next, I didn't have.
Item 17, it will be page 18.
Yeah,
Annex
it's-
C.
it's-
Yes.
So this is the forwarding report of whom?
Of Minturaj Kaman and Chintu Satya. We are Chintu Satya.
Item number 70, Minduras Kavan. That is the forward.
And your loss will find
16 feet, 18, this is forwarding report of.
Item 17.
16 is Chintu Satya, 17 is Minturaj Kaman.
No, forwarding report is not.
Yes.
Forwarding report is in item number 17 of both the accused.
But here it has been stated about forwarding report, but in the petition it is not there.
No, not in my petition. It is there in
No, no,
the.
in your petition it is not
No,
there.
that's why I'm referring to item 70 because is the same forwarding report for both the accused.
Item 17 para.
Page 18.
For both of them.
Yes, ma'am. So basically, my lord, the persons who have murdered, they have confessed before the police that they have murdered. We have been picked up initially on suspicion. Now for 60 days, we are in custody. Your lordship will kindly see the statement recorded because we don't have access, but the statement of Hemanto and Sunil Kos. Because the 161 statement of Hemanto Saike and Sunil Kos, your lordship may kindly look into. And on the last occasion, my lord, when it came for 60 days from this forwarding report, your lordship will find the date. It is 30th of May 2025. And on the last occasion also, my lord, we had pointed out before this honorable court that so far these two persons are concerned, there is no allegation against that. They did not bring the postmortem report. So your lordship has asked them to bring the postmortem report. But postmortem report will be in to know the cause of the death or the nature of the injuries. But your lordship will prima facie see from the statement of this arrested accused person because we don't have it.
So here in this lordship, first I have to submit that lordship here today we have not received the postmortem report lordship, as well as the mobile phone seized from the accused persons that has also been sent for FSL because two of the mobile phone is the iPhone though, so that they cannot open it lordship. So it has been sent for the FSL report, and normally police did not never open it because sometimes it may be alleged that some of the documents may be hampered or tempered by the manipulated. So that is, it is always, it is, whenever it is seized, it is sent to the FSL. And that has also not been received. That report has also not been received, and postmortem report not received. Thereafter, the PCRA has been sent for chemical laboratory investigation. That has also not been received. So, Lordship, at this stage, Lordship, yes, Lordship, there are some statements of the accused person and other person, Lordship. But Lordship, the person who died, Lordship, he, before his death, Lordship, he has stated, he has implicated these persons. That Lordship, these three persons may have brutally assailted her. That is why his position is like that, Lordship. So, Lordship, when that person at the bed of death, Lordship, he has implicated this person. So, Lordship, these postmortem reports are required, Lordship. Because, Lordship, why it is required, Lordship? Because if we go by the statement of the that person, some one or two accused persons, that Lordship, they are simply one person put him on the pushing, he fall down. But Lordship, if there are some other injuries are there, Lordship, then it will go to another direction, Lordship. We cannot say, Lordship, because of the statement of the one person.
In respect of injuries, are there any?
No, Lordship, that is where Lordship postmortem report. No, that is where postmortem report.
My
is
lord,
required,
my
Lordship.
rest.
And that may be
So
called.
how we think
My-
that before his death,
Lordship,
before his death, he
he has implicated these three persons. That's
My lord, your lordship will kindly appreciate one thing. So for postmortem report, whatever report is concerned, this person cannot influence the outcome of the postmortem report. Similarly, CFSL report or the forensic report of the mobile forensics, this person's can't influence that. Your lordship will kindly see the statement of the deceased vis-a-vis the statement of the other two accused persons. If the prima facie it establishes that these two persons, I'm not for the other two persons who have been specifically named by the deceased uncle. So this is a new fact. So your lordship will kindly see the three statements. Then your lordship will take a call that whether the postmortem, because postmortem report I cannot influence, mobile forensics I cannot influence. So to consider my bail, my lord, your lordship will kindly peruse these statements of these three persons. The arrested accused persons, Sunil Kosh, Hemanta Saikia, vis-a-vis my statement also and the statement of the deceased. Nobody is denying that the person has died. He has died. But who is for the cause of the death? Your lordship may look into it. And he is saying three persons. Two persons are named in their FIR. Two persons are before your lordship for consideration of the bill. So naturally, either me or the other item number
He has
17.
indicated the names. He has indicated.
No,
the
you
names.
have said three persons.
He has
So
indicated the names.
he has said three, you have said three persons. Now on before this honorable court, four names have come out. I'm going by the statement of the public prosecutor only, because I don't have that. So your lordship will see whether from this statement my further custodial detention is required or not. Because your lordship need not await, because last occasion your lordship has asked them to bring the postmortem report. Today also postmortem report is not there. The viscera report is not there. The mobile, these three reports, my lord, I don't have any access. I cannot go and tamper with those records. It's there. It is
more than 15.
Today is the 60th day. That in
For
custody.
13-14 days series dying here, Lordship, because on last occasion it was discussed, but court did not, Lordship, that is why, Lordship.
Why you did not return back to his death?
Because Lordship, there is no, as it was called for, and there is no, that on that day, Lordship, this court was not sit.
No, my lord, after your lordship's direction,
Reminder for the case.
Yes, ma'am. after your lordship's last direction, there should be a communication from the office of the public prosecutor.
Last direction. Yes, it is.
For the
On last occasion, Lordship, on that day, court. did
No,
not sit.
prior to that, there was a direction to bring the
Prior to
postmortem.
that, Lordship,
this was passed by the court and by the
Lordship,
justice Cooper. How?
earlier, Lordship, that PM report was called for, but Lordship, when even though Lordship, IO has also some give equation, but that was not received, Lordship. That report was not received. On the day of farewell. And last, it was listed on the day of farewell of the Honorable Justice.
No, no, that is not, you
That
can't
is why it
curtail a
could not
liberty
be-
of a person by not bringing the postmortem report. It's just a
Lordship.
phone call.
Not like that,
Nowadays.
Lordship, on phone call, that will come, Lordship.
On the day of farewell, Lordship was in the division bench. So the
Lordship,
matter was not taken. It
Maybe
was,
this one week time may be given, Lordship, so that it can be called for, Lordship.
So now you're
Actually,
going
maybe
to return it back or what?
We'll Syndicate, because it has to be updated, Lordship. And subsequently, if there are any
Yeah,
other
yeah.
cases has been examined or any witnesses
Your
found-
lordship may call,
Well,
my lord, may I pray, my lord? Your lordship will kindly see the statement of the victim for a moment, my lord. My learned friend has said that he has implicated me, the deceased. Will not disbelieve the deceased. Your lordship will see what he has said.
I am appearing for the informant.
It has to be.
There is an involvement, that is why, my lord, the statement was also given to the police authority. And their involvement is there, my lord.
That is not stated in the FIR.
That's
You have,
purpose.
FIR.
Last purpose. It's one person has been killed, Lordship, they have to.
no, we are not disputing
that.
that. We have full sympathy with the person. I am as an officer of the court. If the statement says that that I have assaulted him, then your lordship will call for the postmortem to see whether the injuries that has been caused tallies with the postmortem report or not. Normally, a person who is on the verge of death will never speak the lie. That's we know the legal principle. But if he has implicated me in his statement before dying that I have caused the injury, then your lordship will call for the postmortem report to tally with his version. But if my name is not there, then your lordship may consider granting bail. And this FIR was filed on my lord 23/5/2025. And in the FIR here, they say that he is in coma and fighting for his life. How a person in coma was gave the statement, I don't know the date, my lord, on which date this statement was given. This FIR was lodged on 23/5, and on that day, they said that he is in coma and fighting for his life at Assam Medical College Hospital, Dibrugarh.
It's just one Sindhu Soikia and then on Minturas Raman. Their names are being indicated.
Your lordship may look for the inquest report also. Sometimes the inquest report also describes the injuries, madam.
Just to point out one more thing. I am for the informant. Here, of course, my lord, the bail application of into Seika. It's itself a defective file. Because this edit section 103 has not been mentioned here in the petition. madam.
No. When we had the copy, we did not have the added section. Your lordship will see the
Because,
certified copy. I have made the submission at the very beginning that now it added
The
section is
petition
there.
was, let me. The petition was filed for bail application on 11/6/2025. And the edit section was made, I order dated 28/5/2025. And in the forwarding report, it was stated that is 35/2025, the added section 1031 BNS is added, and that has not been enclosed in the petition. Once the section has not been mentioned in the petition, how this petition will lie, madam?
My lord, we are
When
not,
lordship will pass any order, then it will be ineffective.
my lord, all
And
procedure.
secondly, the here the deceased is a vikas secretary. He is a pharmacist, and on that particular day, his friends, these are all his friends, they killed him. And one Himanta Saikya was there. Subsequently, Himanta Saikya he has admitted in the forwarding report. Lordship, kindly have a look at page item 17 of the item 17 item forwarding report, man. The grounds of arrest. It is mentioned, man. First, I will go for second ground, but first ground I will read. The arrested accused persons conspired at the furniture shop of Mintu Kaman. It's a this item number 17. At Maskwa Sareli, that the victim Vikas Chetri would be intoxicated and then be killed by the accused, Sri Himanta Saikya, who has already been arrested and remanded to judicial custody. On 2025 at 12:02 a.m. It's midnight. Accused Sri Mintu Kaman received a call from Himanta Saikya. Shortly afterwards, Sri Himanta Saikya arrived at the furniture shop, Sri Mintu Ras Kaman, where Sri Mintu Ram Kaman and Sri Chintumani Saikya intoxicated the victim Vikas Chetri. Then they killed. Thereafter, the accused Sri Himanta Saikya took the victim Vikas Chetri to the place of occurrence and committed the crime. The arrested accused persons appearance before the honorable court cannot be ensured unless they have been arrested under the above section. Now, lastly, the name of address and accused person Mintu Ras Kaman and Chintu Saikya. They are the friends of Vikas Chetri, but ultimately they conspired and killed them. It is the pharmacist, man. And that is why now recently I have come to know that statement has been given to the police by the family members of Vikas. And all these persons have been entangled in the case, man. They are there. Otherwise, if this Vikas Chetri is a healthy person, only this Saikya, Hemanta Saikya cannot kill the persons. He is a healthy person, this Vikas Chetri. Because of all the involvement, he has been killed.
May I respectfully submit, my lord? When you applied for when a
And,
person is in custody,
Up to date case diary, lordship may call for, and as
Yes.
well as other the post-mortem report, whatever,
my lord,
and
no.
this FSL, all this report,
My
everything will
respect-
come out.
My respectful submission is that the informant at the earliest point of time, when he first lodged the FIR on 23/5/2025, there was no mention of this in it. I admit that a FIR need not be the encyclopedia of all the things that has to be mentioned. After this FIR, my lord, when a person is in custody, why your lordship considers always the bail? Because he cannot consult his lawyer, he could not place his documents in support of him. That's why sometimes your lordship's grants bail to the accused too, so that he can prepare his defense. We are not suppressing any facts from this honorable court. Your lordship will recall that at the very outset I said that the person has died and subsequently added section 302 has been added, and that's why I did not have the copy of the FIR because my person is in custody. That's why I referred to the forwarding report of my learned friends item at page 70. And in that forwarding report, it is clearly mentioned that added section 302. All these technical points are always the handmaids of justice. It can't be the mistress of anybody. So just because in my cost title when I filed it, because I filed the FIR on the basis of I filed this bail petition on the basis of the FIR. But now your lordship can always take note that added section 302 2 is there. And your lordship, at the very outset, I have said that added section 302 is there. My contention was that my learned friend, my learned public prosecutor has submitted that there is a statement of the deceased which implicates me. But I find from the FIR page 16 that it says that he is in coma and fighting for his life. That's why I requested this honorable court to verify from the statement of the deceased, because I also honestly believe that a person on the verge of death will not tell lie. But suppose the person makes a statement before his death that I have been stabbed multiple times, but later on in the postmortem report, there is only a single stab injury. That's why on those circumstances, the postmortem report will be necessary. So for forensics of the mobiles is concerned, it will come in the due course. I do not have the, I cannot have access to it. Or I am not claiming custody over those mobile, and I don't know which mobile. It is either Hemonto or Chintu Sekhar that they have not disclosed. That's why I requested this honorable court to look into the statement of the deceased. If in the statement of the deceased it says that there are multiple injuries or then caused by these 3 persons, then it will be considered. But what from both the informant and the hearing the public prosecutor, at least I must be fair to the counsel who is appearing in item number 70. They have not uttered his name. They have all these statements are made on basis of presumption, and criminal law doesn't goes on presumption or suspicion. That's why I requested this honorable court to look into the statement. Rest I leave it to the wisdom of this honorable court, madam. Whether an updated CD will be required or whether postmortem report will require, whether mobile forensics will require. And it's not that the court has not given an opportunity to the public prosecutor to bring those on record.
This is not the case of 326 DPS injury and like this is
I
the case of-
understand. I say it. I say it.
This is the case of murder also.
But you have failed
When
in your
person-
responsibility to bring the postmortem report.
Also, when a person is being killed by, and that too also it is admitted person also, admitted factor also, that prior to the death, all they were along, all along also. Till the midnight, 3 o'clock, till 3 o'clock also, they are along with them also. So also after 4 o'clock, he died also. He was badly assaulted, and how their implications must come, may come also.
Your lordship
Definitely
may
the
also-
implications will come, lordship. And when a person who died, lordship, he has stated, lordship, their names, lordship. So lordship, that is why we are praying for a one-day accommodation, so that lordship, the one accommodation, lordship, so that lordship, we can bring the documents, lordship, because lordship, this is not a simple injury, biggest injury case, lordship. This is a case, lordship, where one person died, lordship, one young boy has died, lordship. When one young boy has died, lordship, so lordship has to ascertain whether there is any other multiple injuries are there. If there are multiple injuries in the postmortem report, then the finger will go to them again, lordship, that they are involved in this, because there are no other persons are there along with them. They themselves have admitted, lordship, that they are along with them. But when one more thing, lordship, I have to point out, lordship, that lordship, I have as per the instruction of the IO, lordship, that is, lordship, that in the statement of the Sintu and Mintu, they said, lordship, they have they after some time they went back to their home, but it is a far place. But lordship, when lordship, the mobile tower lordship location they say, lordship, it was the same mobile location which is at the Himanta, Sintu and Mintu. They are all the same in mobile location. They were talking each other at the time, lordship. All so lordship, finger will definitely go to them. Point to them, lordship. So lordship, at this stage, lordship, let the postmortem report come, lordship. It is 60 days only, lordship, because it is 90 days period, lordship, and lordship, only because of 60 days he is in custody, lordship. And when person is dying, young boy is being killed, lordship. So lordship, that has to be a certain, lordship, after going to the CD, lordship. Postmortem report, lordship. Their visa report is also required, lordship. Their mobile phones are also required, lordship. Their mobile phones has been sent to the FSL report, lordship, because that is also not received. Even though, lordship, that is different thing, lordship. Even if it is received or not, that is separate thing. But lordship, postmortem report is a vital document to ensure there is whether it is how a person has been killed, lordship. Because lordship, as the Himanta, as per the Himanta, if it is he has stated, lordship, I push him, he fall down and he died. If there subsequently, if we found that, lordship, there are multiple injuries in his body, then how that injuries come, lordship? So lordship, let the postmortem report come, lordship. Therefore, lordship will ensure.
No, just one moment. Your lordship will see how they have made the statement. First, they made a statement before this honorable court that we are awaiting the mobile forensics. We have not opened the mobile because there will be an allegation of tampering with the mobile. Now he says from the mobile, I know the location. He-
From CDR, it can be.
No, no.
It
Ah.
can from CDR.
No,
receipt.
your lordship, at the very outset, I have said that if from the deceased state,
Mobile.
they have made a statement that from the statement of the deceased, my name is implicated. If your lordship finds, I don't have access to the statement. If your lordship finds from the statement of the deceased that my name has been uttered by the person who was in coma as per the FIR, then your lordship will call for the case diary to see whether that statement matches with the injury report or not. Because in their own FIR, they say he was in coma.
But there are some oral dying declaration are there. I have come to know. Now let us see, because.
But in my lord, in the oral dying declaration, he implicates me, my lord.
Part is one of the co-accused, or there are some co-accused, simple, one of blow was there and one he made a cushion there, but obviously we don't have anything before us regarding the injury sustained by the deceased. Whether there are any other injuries, we are not in a position to say anything.
No, my lord, I'm not talking about the injury, my lord. Does the deceased implicate me, my lord?
Yes.
Then
There
your
are-
lordship will
there
call
are
for the, well, that they can say, but if that is there, then your
I'm
lordship.
saying from the very
No,
beginning.
no,
Lordship.
no,
I'm
your
saying from the very
statements are
beginning.
contradictory.
No, I'm
Your
saying from the very
statement,
beginning, I'm
and
saying
it's not
that-
that this honorable court has not granted him the opportunity to bring the postmortem report. Your lordship will see the order. Last date, for some reason, the court has not said. That's why you will not bring that cannot be a justification. Because at the same time, we are concerned with the liberty of a person. I have full sympathy for the person who has died. Did I at any moment I said that I don't have any sympathy only because, but your personal liberty has to be matched with the rights of the deceased vis-a-vis Article 21, my lord. That's I need not repeat those elementary concepts before this honorable court, my lord. So I pray, my lord, since the two opportunities have gone, my lord, I'll pray that your lordship will fix a short date for consideration of my bill. Either way, my lord. Let them produce the postmortem
But your
report.
submission- the difficulty to, because now there are some reasons I have gone to the case check.
If
Where
lordship,
we
he
see
has
that,
implicated me, lordship.
Report or the injury report which is required, may not be a physical report, but other report. Suppose mobile phone, those two mobile phones have already been.
If
sent.
if specifically implicated, Mintora's command, lordship.
This is
Then
basically
the
your shop house, I think, where all the, it was conspiracy was there in fact, in your own shop. You have a shop house, I think furniture shop house or someone, like I don't know. So there only the entire conspiracy was there.
then lordship call for it.
So we are calling for the medical report. Is there any other injury?
Yes, yes, ma'am. Well, we can wait. Your lordship may then kindly fix it on 1st of August. Let them have it, the report by then.
First of August, how it will come, Lordship? We will be sent back a CD, Lordship, they will send back it as Lordship.
No, if you retain the city then.
Only the postmortem report has to be brought, my lord.
Because Lordship, up to the CD is also required, Lordship, in that case, Lordship, because from last 14, 15, 13, it is lying with us, Lordship, CD is
Yeah.
lying here now. So updated is also required. Lordship, can you fix it on? Because it has to come, Lordship, we do not know whether it has already been received or not, Lordship, because today we will communicate him, Lordship, that the CD is come, Lordship. On 8th, Lordship, 8th of August.
Well, may
Then
pay it
six,
on.
Lordship,
Numbers of cases.
six, priority, Lordship, it will be difficult, because Lordship, it will be, they will come, Lordship,
Two opportunities have already gone.
Fifth or sixth.
6 will.
Well, we have no objection for 6 months. Let it be on 6. Subject to your lordship's consent, but let us have a attempt on 6 months.
You're going to return back? Yes,
So we will send back this.
Yes, Singh.
70 years of It was lying since when for 15 days. 15 days CD is lying here. Since that 15 days CD is lying. Submitted that for second case like, as the industry to be with. In of the big case, like, for the 50, for the- in the file for the- We are helpless in effect regarding the dates because it's everything. I know that matters are urgent, but anyway, with the fact for is that I will just like that, but it is there all for the
On 6th, that's it.
six.
Both cases.
Good.
We are net.
Lordship, regarding item 19, Lordship, this matter can be taken up next week, Lordship. Item 19, item 19,
19.
Take this on next week.
next week, any day.
Next week, again, that is the problem. Next week on. Maybe on 12th, maybe on 11th of.
Oh,
11. By listing it on 11.
highly over.
Pilot here, charge sheet submitted.
Yes, yes.
I charge sheet number 130 of 25,
One,
Dated
three,
130, public 25, dated 305/25. Hard disk.
State respondent. This was with body case diary, but it was submitted by Mr. Sharma. That case has already been charged. ICS number 130 of the 2025 dated 30/05. In view of this, the petitioner is thereby directed to appear before the to appear before the learned trial court below and will file a regular application for bail, which may be considered in view of this. Okay.
My lord, this matter, my lord, that is in the cause list, my lord, that is the office note was there. But during that time, my lord, that is the trial court record was not, my lord, tagged with the file, my lord. In the meanwhile, now it has come, my
In the morning, it was mentioned, madam.
mentioned, my lord.
Lordship said
My lord,
that
allows some time, my lord, I will go through the same in the meanwhile, my lord. Or,
Okay, so I cannot see. If you can complete it, then okay.
okay,
By today itself,
but today it's a.
After 2-3 items, my lord, I will.
or what time?
এখন করবি না এখানে? এখানে? মনে করলে
52 and 53, you are appearing.
Yes, ma'am. Case
You are for 53. In both the matters, you are appearing. It is out of same affair, Baba Thakur. Out of same affair.
Out of same affair, madam. Bosista PS 32125.
52, this one. Yes, which item? 52? 52 first?
Item number 52 and 53, madam.
Yes, yes, you are first, we are going to 52. Huh? Honor the time. Mike, honor the.
Allegation is of ATM card swapping method. And those elderly person came to withdraw their money and they were seated by some person, my lord. Present, as per the present affair, my lord, 4 number of accused, I am for the accused number 4, my lord. And as per the statement, I have been accused, made accused, my lord,
Your petitioner is accused number 4,
4,
as per FIR.
as per FIR. Go by this FIR, my lord, for forwarding report itself, page 23, my lord. Para 3. During the investigation of the PO, ATM was visited with the complainant of the incident case and collected CCTV footage of the incident, the ATM card theft during ATM card swapping. In the CCTV footage, the arrested accused Aminul Haq, son of so-and-so, and Shohidul Islam, so-and-so, were captured and they were identified. I am not of them. Even CCTV footage itself says they are directly involved.
But these are the ground of arrest of whom? Other person.
Other person.
It is not your ground of arrest. One Lutfur and Mohibur.
Mohibur, right.
So you are saying you are not involved. Yes.
Case they received, my lord, considering their, my lord, these all persons are involved in committing, these are organized, my lord, racket of committing this type of offense. Initially, my lord, they targeted all peoples in the ATM, my lord, and thereafter, my lord, they exchanged the ATM of all these, my lord, victimized persons, and thereafter, my lord, swapping that ATM, my lord, they withdrawn money, my lord, in a deceitful manner, my lord. And during investigation in this case, my lord, the, my lord, victimized person is, my lord, one. During investigation, my lord, as leaded by these accused persons, the ATM card of the complainant Umesh Kolita was also recovered, my lord.
By
Along
these
with,
two, by these two.
from the all the accused persons, my lord. Initially, police arrested, my lord, Aminul Haq. And your lordship may kindly, I'd just like to point out, my lord. The Caesar list to tell, my lord. 30 numbers of ATM cards were recovered, and from among those, my lord, ATM cards, one ATM card of the present victimized person, my lord.
In regards to involvement of this 52 and 53, are there?
Yes, ma'am. And on being, accordingly, on being leaded by Aminul Haq and Sahidul Islam, proceeded to Alpine Homestay to recover the ATMs. So now, thereafter, on being leaded by Aminul Haq and Sahidul Islam, arrived at Alpine Homestay and seized total 39 numbers of ATM.
But this petitioner has one Mahbubur and one.
Mahbubur Rahman, yes, later on, my lord, Mahbubul, on the basis of the statement of the other accused person, he is also one of the associate of all these accused persons. Later on, Mahbubur arrested, my lord. Mahbubur arrested on 11/6. Other accused persons were arrested on, my lord, 10/6/25.
Yes.
And my lord, again like to point out, your lordship, that here by order dated 36/25, sections 102B, 111(3), 111(4) of the BNS added, my lord, against all these accused persons.
102,
112(2)B,
112,
111(3), and 111(4) added against all these accused persons, my lord. And well, the accused person, although against Mohibur Rahman, my lord, I have not found that whether any other cases registered against him or not. But regarding other accused persons, there are lots of, my lord, cases of the similar nature, my lord, already registered against all the accused persons. All are habitual offender. And later on the basis of their statement, my lord, Mohibur Rahman was also arrested, and he is also an associate of all these accused persons who are running a organized syndicate for committing all these offences. Your lordship may kindly the
If,
number of cases against all these accused persons, my lord.
May please, your lordship, I am the item number 53, lordship. The lordship, in this case, lordship, 1 of 48 notice was not served. The said accused person, lordship. 48 notice, lordship.
47.
And the length of detention today is 49 days, lordship. I am not in the merit, lordship, on the length of detention, lordship, consider the bail application. 49 days, and the notice was not served upon them.
All are habitual offenders, my lord. My lord, against all these accused persons, at least, my lord, 6, 7, 8 numbers of cases are pending, my lord. Considering all these aspects, my lord, length of detention cannot be a ground for granting anticipatory bail, my lord, or bail, my lord, at this stage, my lord. Otherwise, my lord, there is a note of the IO also, my lord, because of the illness of the victimized person, my lord. PIP is also, my lord, not yet done. So PIP is also again required to be done as one of the note of the IO is there. Otherwise, from the materials available on record and from the, my lord, number of cases already registered against all these accused persons committing this type of similar kinds of offences, my lord. Length of detention cannot be a ground for granting bail.
48 not served, lordship.
48
notice
48
not
is
served.
there, my lord. Section 47, 48 notice is there in the bill.
No, lordship, my 3 accused persons, no notice was served upon them, lordship.
You are representing 3 accused,
3, lord.
1 Lutfur and other 2.
Lordship.
Mohibur
At the time
Rahman
of
is
lordship,
item number
I have
50.
no documents, lordship, but at the time of Ezahar, lordship, the Luthor is in the judicial custody. The length of
Aminu,
detention,
Sahidul and Lutfur, you 3 were together.
lordship,
Forward.
3 years, lord. 53, lordship. Then the lordship, the notice was not sent, 48 and the article 22, 1, lordship.
All 4 were on police department.
Yes.
4.
Yes.
When is Manolo when everything
Yes, I did. Your petitioner is in on custody for since when?
As on today, my lord, 48 days, my lord.
You are on 49.
49.
Officers are of the part of the record, 47 and 48.
Yes, you are complaint.
48 not sir.
Page 25 of item number 52, my lord, providing report also specifically mention enclosed copy of notice 57, copy of notice 48. I'm just pointing out because he raised this one, my lord. Otherwise there are from the materials.
He is insisting 48.
Yes, okay, your lordship may kindly, I will point out 48 is also there. And here page 25, your lordship may kindly page
It's
25
25
of
of 52.
Mahbubur Rahman, my lord, item number 52. Enclosed, my lord. It is forwarding report of all the issues.
Enclosed. Only for enclosed. Enclosed take করেছি।
Copy of notice 47.
Enclosed sorry. Not sir.
40. Mr. KM Hasan.
J. Ahmad.
Yeah. Same হবো দুইটা 52 হচ্ছে JM Ahmed আর 53 হচ্ছে এনাম administrator KK administrator equal submitted by Mr. Ahmed. He done it also for the petitioner that his petitioner is innocent and no way connected in the alleged offense. He has been arrested in connection with this case only on suspicion, and since last 48 days, he is behind the bar. Thus, the Ayog got sufficient opportunity to interrogate the present accused petitioner, keeping him in custody. And hence, further custody interrogation may not be required for the purpose of the So, তেখেতৰ পেন আহমেদৰ submission টো same submission থাকিব। খালি তেওঁৰ তাত আৰু এটা submission লগাই দিব যে 48 notice has not been served। সেইটো লগাই দিব। Next para. Mr. Portapu did an additional PP submitted in this regard that there are sufficient incriminating materials.
Nominated person is Zakir Hussain and the accused name is Aminul Islam and the next case Tawhidul Islam.
Zakir Hussain is the brother of the Mahabul Lordship.
Huh?
They have not known the Zakir Hussain Lordship. Other
Mr. Portapu did an additional PP submitted in this regard that there are sufficient incriminating materials against the present accused petitioner. And on inquiry, it has come into the light that these accused petitioners are the professional thieves, and they are working in a organized manner. And their entire gang is actively involved in similar ATM card swapping incidents. Full stop. Their modus operandi involves creating fake ATM cards in the name of some unsuspecting individuals, which they were primarily target elderly persons in ATM booths. And deceitfully engaging them in conversation, then swapping the victim original ATM card with a fake one. Mr. Bhattapur submitted that the case is that by order dated 30/06/2025 on the prayer of the IO, the sections 1112 subsection B, 1113 111 subsection 2 subsection small b, 111 subsection 3, and 111 subsection 4 of BNS has already been added against the present accused persons. It further submitted that considering the nature and gravity of the offense, considering the length of detention only, the petitioner cannot be enlarged on bail. Full stop. More so, he submitted that this accused petitioner also have similar kind of also has various cases pending against him involving similar kind of offenses. They are the habitual offender, and hence their further custodial interrogation may be required for the interest of the investigation. Mr. Bhattapur accordingly raised remand objection in allowing the accused petitioners to go on bail at this stage. In that context, Mr. Bhattapur further submitted that the provision of section notice under section 47 and 48 are also complied with, and the accused petitioners were and detail of the detail of the crime is mentioned in their notice issued under section 47, BNSs. Booster. Next para. Considering the submission made by learning counsel for both sides, I have also perused the case record and the case diary, wherefrom it is seen that all these accused petitioners are involved in similar kind of offenses, and they are found to be habitual offender committing a similar kind of theft. It is seen that as per inquiry report, they targeted mainly the old persons in the ATM booth, and in the name of swiping the ATM card, the name of swiping the ATM card, they used to they used to swipe they used to withdraw the money from the victim's account using those card, and thereafter they used to create the fake ATM cards in the name of some unsuspected persons and some suspected persons. So considering the nature and gravity of the offense, do not find it a case to extend the privilege of bail to the present accused accused persons as that at this stage, and hence the same stands to take. Further, it is seen that there was total compliance of 47 and 48 at BNSs while issuing the at the time of the arrest of the defendant. So considering this aspect of the case, vis-a-vis the vis-a-vis the gravity of the offense, I find that further custodial interrogation may be required to unearth some more facts and to apprehend and to nab some other culprits who may be associated in the case. In view of this, so that both your petitioners then dismissed.
The Lordship, the petition item 53.
The
No allegation.
order is already there, so no.
Lordship, no allegation against the Lutfur Rahman. Lordship. No allegation, Lordship.
Rejected.
My lord, here in this matter, my lord, I have gone through the my lord trial court record, my lord. But my lord, this trial court record is not complete, my lord. Here, my lord, that is the CD part, entire CD part is not available. Otherwise, my lord, the case is at the my lord, charges is already being framed, and now it is at the evidence phase, my lord. Search frame, my lord, search frame on my lord, that is on 22/7/2025. And next date for my lord, evidence is fixed on 19/8/2025, my lord.
So in this case, madam, only your lordship will see whether his father custody is required or not, my lord.
My lord, for that reason, my lord, because my lord, here, the FIR, my lord, that is my lord, the sections are, my lord, 113(3), my lord. The everything
Basically,
thereof is like
153A area.
96 and 197(1). So these are there, my lord. For that reason, my lord, CD is required.
Now you have received not the CD
No, not entire, but my lord.
Scan copy was
my-
called.
my-
Scan
Scan
copy was
copy
called.
of the my lord, that is the record is received, but not entire by my. May kindly peruse the same.
Oh, it's not there.
Yes, ma'am.
Whether it is required, you kindly see my FIR, my your lordship, kindly. Whether further, already my 90 days already over, no charge should file my lord. Further custody on the face of the allegation, my lord, whether it is required or not. Allegation by the 153A basically, my lord. He has supported one given scheme regarding some Pakistan, that Pahalgam, regarding Pahalgam, my lord. Whether this amounts to 153A or not, my lord, whether anything happened, nothing happened, what is the intention, whether he had intention to promote enmity between the two groups, my lord. Already everything is there, my lord, in the recent Supreme Court judgment, so there, my lord. For that, when 90 days already he is there, my lord, and he is not a man of that politician or very important person, my lord. Grocery shop, my lord, he is having. By the accidentally, my lord, mobile, my lord, he touched it, and ultimately this is tongue off, my lord. This is the allegation. Page 15, my lord, you'll also kind of page 12, my lord. 13, 14, my lord. FIR.
If,
Very
the
small
copy
amount of
is
one
also
is
not here.
My lord, here, my lord, that is the FIR dated is 28/4/2025.
Yes,
And my lord, that is the Pahalgam terror attack that was on my lord 20/4/2025.
right.
My lord, within the
Immediately
7 days, that period, my lord, he was arrested on 29/4/2025, my lord. So because of that reason, my lord, that's my humble prayer.
Now everything has gone, my lord. Everything has come down, my lord.
Otherwise, it is, my lord, a different case. I will not, my lord, place before.
No,
the
no,
lordship.
I am absolutely with him, my lord. But my only question, my lord, further custody, I am only on that, my lord. Nobody support, my lord, if he has intention to do it, my lord. Nobody, I cannot be, I am the last person to, my lord, condemn it. That is not there. Only thing is further custody.
Very serious allegation. After the
My-
Pahalgam incident, you post
No,
all
my
the
lord, what is the allegation against him, my lord?
supporting the
That,
enemy
that matter,
country.
that, I am absolutely with lordship, my lord. I'm not saying so, man. But my question, my lord, on the face of it, my lord, whether he had intention, my lord, Supreme Court, my lord, time and again said, my lord. Your lordship, just I'm heading over, my lord, your lordship, kind of go through it and your lordship pass any order, my lord.
Mr. H.R.H.
Okay.
Assisted by Mr.
Assisted by Ayu Chaudhary.
Ayush Chaudhary, Ilan Council for the petition, and also heard a motion Ilan Syndicate appearing on behalf of the. It is submitted by Mr. Busher that the scan copy of the TCR has already been received, but on further
There you go.
seen that the entire case diary and the case record is not available in the scan copy, which is received by the registry. In view of this, the registry is hereby directed to call for a complete record of TCR along with the scan copy of the case diary.
Registration.
Post a registry will do the needful in this regard. When it can be called, because they are in custody for
Registry, my
My
lord.
lord, my lord, registry.
2 days. No, but any timetable day.
Already, my lord, 90 already. I think nothing remains.
Here it is the table. Sorry, this day before 8 is not possible. Let it be on 12th or 30th. Before 8, it's not 8 to we are not listing a very less numbers of matters.
I lift your lordship, my lord.
5 days was 12.
You know, your lordship also type the matters, but here also, we are also, my lord, under pressure, my lord. That both the things you are possible to make that balance, my lord.
Okay, 12th of August. Okay, Mr. Yeah. Oh,
Right, please, your lordship. Also, in this case, a report was called for, my lord, whether any case has been lodged against the petitioner or not, my lord.
what?
My lord, we have received one report, my lord.
Huh.
As per the report, my lord, no cases, my lord.
So earlier on the last occasion, first occasion on the 24/6, it was in submission made by Mr. Amir that the petitioner had lodged on one NI case
Yes,
against one Vijay Kumar Sinha,
yes.
which has already been registered and depending before the SDGM M. Bilasipad. So there was an apprehension that there may be any case registered against the present petitioner in the this
Bilasivara police.
Bilasipara, but not received.
Matter may be closed at this day.
Yes, and you will be liberty to file, make a mention of it.
Yes.
Hard Mr. You are Mr.
You can.
You can hard Mr. You can then petition. So hard Mr. Devotion then respondent. Next, it is submitted by Mr. Busher that the report is received from OC Bilasipada. Okay, stating that after verification, it is seen that no case is pending against the present petitioner. in Vilasepara police station, nor any FIR has been lodged till date. In view of this, the present case is hereby closed. However, the petitioner is at liberty to file fresh application in the event of registering or filing of any FIR. The report of the officer in charge Vilasepara may be kept as part of the
Madam, deeply obliged.
May please your worship. The previous bail application, my lord. FIR is at page number 15.
1-5.
1-5, my lord, vernacular. But the case is that, my lord, 3 boys and 2 girls, my lord. They went, my lord. They were, my lord, making some videos, my lord, short videos. They were shooting some short videos on this Kalahat overbridge, man. Thereafter, my lord, in the evening time, man. Thereafter, my lord, the local villagers, my lord, they came and they objected to that. They objected to this activities, man. Thereafter, my lord, some of the villagers started scolding and then also assaulted these boys. Boys means, my lord, the present petitioner, then accused number 2 Alimul, and the alleged victim. These 3 boys and 2 girls, man.
3 boys, 2 girls.
2 girls. Petitioner is the accused number 1, Mufizul Haq, and his friend Alimul, and the one who got injured, my lord, that is Sofikul. Sofikul. So these are the 3 boys and there are 2 girls, man. Thereafter, my lord, when they were being assaulted by these local people, my lord, this victim, my lord, this alleged victim, he got scared and he jumped from the overbridge, my lord, and he landed on a hard surface. There was no water, my lord, so he landed on a hard surface and he received injuries. Thereafter, my lord, the family members of this boy, they lodged this present FIR, saying that, my lord, it was the present petitioner and his friend who had pushed this Sofikul from the bridge, my lord. Now, if your lordship will kindly see the FIR, my lord, page number 15, from the middle, my lord, on around 5-6 line, my lord. সেইমতে ৰাতি 8টামান বজাত মোৰ ভাইটি কালাহাট অভাৰব্ৰিজৰ ওপৰত আহে। পদকীয়াগণে 4-চকীয়া বাহন দেখুৱাই মোৰ ভাইটিক উঠিবলৈ কয়। মোৰ ভাইটি গাড়ীৰ ওচৰত গৈ গাড়ীৰ দৰ্জা খুলি দেখা পায় যে গাড়ীত 2জনী ছোৱালী বহি আছে। তেতিয়া মোৰ ভাইটিয়ে ছোৱালীৰ লগত মেলাত নাযাওঁ বুলি কয়। লগে লগে আছামী 2জনে মোৰ ভাইটিক লগত কিয় নাযাবি বুলি কৈ তৰ্ক বিতৰ্কত লিপ্ত হয়। আছামী 2জনে মোৰ ভাইটিক মেলাত নগলে মাৰি পেলাম বুলি কৈ অভাৰব্ৰিজৰ ওপৰৰ পৰা পেলাই দিয়ে। মানে দিছ ইজ দি ৰিজন, মাই লৰ্ড। And why would somebody, my lord, threaten someone to kill just because, my lord, he refused to go to a mela, my lord? From the very, my lord, FIR, it looks like, my lord, this has been is a result of an afterthought. So, my lord, my humble submission is that, my lord, actually, this was a result of, my lord, the victim himself jumping from the bridge just to save himself from the local people, man. And he had sustained some injuries, my lord. The injury report will reveal whether it's a case of simple injury or, my lord, it's a grievous injury, my lord. The FIR has been registered under 1091, that is attempt to murder, and section 35.
But it was just named accused two persons.
2 persons, my lord.
So you are for?
Petitioner number, this accused number 1, Mufizul Haq.
Here, my lord, in the vernacular part, my lord, that is in, my lord, page 15, my lord, last, my lord, page 16, my lord. Sofikul Rahman গুরুতর ভাবে জখম হয়ে অজ্ঞান অবস্থাত পড়ি আছে, my. So that is, my lord, is stated in the, my lord, FIR, my lord. And, my lord, that is the story of the, my lord, accused petitioner, and the, my lord, that is the prosecution's, my lord, that is the fact, that is the FIR is something, my lord, different.
Obviously,
my lord, here, my lord, it is stated that, my lord, that the আসামী 2জনে মোৰ ভাইটিক মেলাত নগলে মাৰি পেলাম বুলি কৈ অভাৰব্ৰিজৰ ওপৰৰ পৰা পেলাই দিয়ে। অভাৰব্ৰিজৰ ওপৰৰ পৰা পেলাই দিয়ে, my lord, let the CDB call for, my lord, In the meantime, my lord, along with the my lord medical report and all, because my lord, here my lord, it is stated
Submitted
that-
by Mr. Das, why Mela?
Yes. Yes.
My lord, but before that, my
Sir.
lord, there are some different parts also there, my lord, because my lord, he started with my lord, that is the, my lord, he was not ready to board us into the cart, my lord, because of there are some other occupants are there, some girls were there. That was there. So my lord, let us
So
become my
girls
lord.
were there, so he may refuse.
Yes.
Suppose girls were
My
there as per the FIR story
My lord.
also.
Yes.
Two girls were there, so
My lord,
he refused.
he refused, my lord, but therefore, my lord,
Well,
other part, my lord, that he was, my lord, what?
Just because someone refuses to go to a Mela, my lord, will that be a reason for these accused persons?
My lord, that also,
Certainly.
my lord,
Ah,
but my
because
lord,
he
Can
refused
that
to
be a
go
reason, my
with
lord?
those two girls,
yes, my lord,
as per the FIR also,
Yes.
he refused to go with those two girls
yes.
in the same car.
Well, obviously that part is there, man, admittedly, because that is also, my lord, there may be some link, maybe, I don't, but not, my lord, entirely going through the FIR. Man. That's true. Man.
And my lord, the case has been not been registered under any my lord sections pertaining to grievous hurt or hurt. Only it's 1091 and 35.
109 means his condition was that
The
was
condition will
it's an
admittedly,
attempt,
my lord,
it's
it
an
will be
attempt.
grievous because he had fallen from that bridge, man.
No, obviously,
Yes.
that is the
Yes.
the prosecution story that you had an attempt.
Yes.
Hard Mr. Esther stated the complaint. But the abortion did not be one of the steps. It is
My lord, only one submission, my lord, 8, my lord. My lord, the annexure 2, my lord, that is the earlier rejection order, my lord,
Yes,
where my
right.
bail was rejected, my lord.
Right.
Here on the, my lord, there is annexure to page 17, my lord. My lord, there is the, by the, my lord, that is
Yes.
the line code below, my lord.
Mm.
So where, my lord, in the item, my lord, there is a paraphrase, my lord, where it is stated that I have produced the various statement of witness, including the victim, Sofikul Rahman, recorded under section 180 BNSS. The victim has clearly implicated the present accused person, and he has stated that the present accused actually pushed him from the bridge because of his, which he sustained grievous injury. Only that part was there. Otherwise, my lord,
Let the city
FIR
come,
is,
man.
my lord, that part is
Let the city come, man.
was there.
And
Okay then, let the CD come. That may
Yes.
not be in the
Well-
interim may not be considered. Let the CD come. We'll see to it if there is any.
Any date,
Otherwise,
my lord,
yes,
we will-
there's an observation made by
Yes,
I know.
session judge that it pushed him.
My lord,
But the other witnesses says let us be verified.
my lord.
Because Mr. Das is something that
Well, he
they were
blame him,
preparing
my
some
lord.
videos
That I
and
understand,
all.
my lord, because my lord, in the FIR also, that part, my lord, because there is no link will not come out from that FIR. Because of not going to a, my lord, Mela.
Mela, yes.
Yes, ma'am.
So let us call for the case diary along with the report.
My lord.
Let us see the report if there, if in case, if the, interrogation is required in custodial, then
Fine.
we'll see to it otherwise.
Fine.
So CDB call for, when it can be called, Kakinalaki, CDB.
But any date.
Yes, Mr. Das, any date,
up to your lordship, man. Any short date, madam. Next week.
no short date, that's why I'm asking.
My lord.
We don't have any short date.
Then,
Short-
my lord,
don't have.
so lordship gives us the liberty to appear before the IO, my lord, so that our part of the story can also be brought on record, madam.
Anyway, we'll leave
Yes.
the case diary and if required and after perusal of the case
Yes.
diary also, you may be given a chance.
Mine.
But don't have any, at present, we don't have any such kind of shortage, but let it be on 12, 13, 14, 12, 13, 12, 11.
My lord.
Wait, 11. Oh, let's see.
Highly obliged.
One, 21 report back. 20. 28, which are
21. May it please your lordship. Lordship, the petitioners are on interim, your lordship, and lordship, this petition was on interim for more than 1 year. CD was earlier there, but there was a direction to bring the updated CD. Only to see whether these petitioners have appeared or not, your lordship. I have instruction, they have already appeared, and the co-accused already granted bail by this honorable court, your lordship.
This case already charge sheet also, my lord, submitted.
Case is of civil nature, your lordship.
Whatever, charge is submitted.
Twenty-one to
21.
21, my lord, case diary not received. Sorry.
Many occasions, your lordship. Lordship will kindly see the order of bail granted by
Yes, it is that case of 2024.
24, your lord. And they are already
The
in.
issue, this 24 is pending.
Yes.
Your interim was on 20/08/2024.
Maybe made
So
absolute
almost 1 year.
co-accused granted bail, anticipatory bail by this page 34, lordship may kindly see.
34.
34. At that time also, they did not bring the city ultimately without appraisal of the city, the court granted. Page 35, lordship will see. It is a case of civil nature, your lordship. The petitioners have mutated their names. The others, they are all
Is
cousins.
there any civil cases also pending at present? No.
No,
civil
they have
regard-
not filed any civil case. In respect of mutation, it is their claim that we have mutated our names by forging some documents, your lordship. The case of civil nature.
Allegation is of, my lord, tempering government records is also there, my lord. They are by tempering.
The
government-
question is that this, since the matter is of 2024 and 20/08/2024, it's a
Yes, well, then my lord, his statement may be recorded that they have appeared and cooperated in the.
as per your instruction, your
They have
statement is
appeared.
recorded
Lordship,
as per your instruction. If
appear.
not recorded, then direction may be there.
Yes.
Your Mr. M.H. Laskar,
MH Lordship.
part Mr. M.H. Laskar, detained counsel for the petitioner. And also part Mr. Freeport, detained petitioner. This is an application. Swenson. Submitted by Mr. Laskar that the present accused petitioner obtained their interim bail on 20/08/2024 and they accordingly appeared before the IR and their statements were also recorded. But since 5/12/2024, case is pending for sealing, but till that the IO could not punish the case that better repeated of the reminders to the IO. He further submitted that the case is of civil in nature and some of the documents were already collected by the IO and they are still ready and willing to cooperate. The IO in further investigation of this case. If they are granted with pre-request. Mr. Potter submitted in this regard that the from prosecution side there were several intimation were made to the IO, but it is the fact that the IO could not punish the case that it. The Potter submitted that
Earlier, my lord's case they received. Sent back for updation. At that point of time, also a statement of petitioners were not there.
Acha. Mr. Bottock further submitted that the case diary was earlier received by this court, but as the statement of the petitioners were not available in the case diary, updated case diary was called for, and but however, the IO failed to produce the updated one. Report recording submitted that there are some serious allegations of forgery, and hence perusal of the case record may be necessary for the interest of the investigation. May be necessary for the disposal of the data. Better considering the submission, I have also perused the case record. It's seen that there are the cases otherwise seems to be civil in nature, though there are some allegations of forgery of documents, but it's seen that in spite of the depths of more in fact of lapse of near about 1 year, the IO failed to produce the updated case diary. In view of this, I find that the, the the order of interim period split dated 12/20/08/2024 may be made absolute with same terms and conditions. And further, the petitioners are hereby directed to appear before the IO and cooperate in the further investigation of this case, as well as their statements may also be recorded by the IO if it is required for the interest of the investigation. In purpose, the interim period is split dated 20/08/2020 is hereby made absolute same terms and conditions.
Obliged.
Overpass. One affidavit was supposed, you have a file
Yes,
one
come.
affidavit.
Yes,
My lord, the petitioner before lordship is on bail since 23/9/24 on interim bail. Lordship can see the order 23/9/24. Since then, he's on bail, then lordship CD, then CD come. Then in the meantime, lordship on 10/6/25,
Yes.
my learned friend appeared and they filed an objection to granting bail. Then this court passed an order on 10/6/25 at para 4, lordship. On the other hand, learned additional public prosecutor as well as learned senior counsel appearing for the informant had objected the bail entry mainly on the ground that during the substantiation of the interim protection given by, he has misused his liberty and has threatened the victim girl on 9/5/25 over mobile phone. So this court said that you send the report, whether it is correct or not. It is the para 6, lordship. Therefore, in view of the above, let the report be called for from the officer in charge of the dispute police station as to whether any police station case has been registered on the basis of the GG entry or as to whether any inquiry has been conducted and what is the preliminary finding on the basis of the said inquiry. The report should reach this court on 24th. That is why on the last day, they took time that it was not completed, lordship, and then it was CD was not there. And today, my learned friend has bring the CD and the report.
Yes, my lord, I have received the report, my lord, dated 25/7/2025. You have received, there are two parts of the report, my lord. First part is the, my lord, regarding the allegations against the present petitioner, that is the bail application. Second part, your lordship, I have flag mark, my lord. Last portion is the information, my lord, regarding the query, my lord, raised by my lord, regarding.
It's a report.
Yes, that is a report. First part is the
all of them, I lord. Additional activity.
Yes, so there is a report.
yes.
So, Lordship, I have filed an objection to this his application, Lordship. That is at page 156.
Fine today.
Filed today. Page 156, Lordship.
Today's affidavit.
Yes, today's actually. That page 150.
Lordship, may please directly come to page 158.
Second line.
Second line, Lordship.
Yes.
It is stated that each and every statement contained in the said annexure A document is
Complete.
falsely derived on any factual foundation whatsoever. This is evinced from the said document itself and the informant objection, wherewith no screenshot of the WhatsApp call log of the informant pertaining to 9/5/25 and B, the contact details of the instant deponent as saved in the informant phone have been provided. These two details are necessary to substantiate the allegation is so. It is humbly submitted, otherwise the bail petition can be frustrated to informant in the manner by merely asserting without any documentary proof that a bail petition has been attempted to threaten informant. It is stated that the omission of existing so has been made by the deponent informant on 9/6/25. Now, Lordship, in the affidavit, Lordship, my learned friend has given. Lordship, may please come to page 154. The objection. Objection is, it is started at page 137, Lordship. Lordship, may please come to page 154. See, anyone can file this type of complaint, Lordship, during the pendency, Lordship, after 1 year. I am there in the interim order, Lordship, from 9/3, 23/9. And now, Lordship, at page 154, this is the objection, Lordship. No screenshot, nothing. Only saying, even time is not there, Lordship, at what time the call was there on here. Nothing. If, Lordship, someone will call someone on a WhatsApp call, at least the time should be given that at this time he was called me, or nothing was there, Lordship, just to file, just to harass me, Lordship.
This of course call local account. Two different.
I am on bail, Lordship, from 23/9/24. I visited, my statement was recorded long back. Twice I visited the police station. Then the police went to my house. There was a search in my house. After that, all this, Lordship, the affair is very simple, Lordship. There is nothing, Lordship. Lordship, may please come to the affair as page 34.
But
Lordship, this affair, Lordship,
yes, page at
page
FI.
34, Annexa 1 to my petition, Lordship. This is the right copy, Lordship. Lordship, good.
Yes.
I'll skip something, few line, Lordship, that I was the relationship so-and-so, in relation and temporary resident of so-and-so. He is the so-and-so organization. We had been in love relationship, Lordship, get it? We had been in love relationship for 3.5 years since 2021. Lordship will take note. During this time, so-and-so has visited my home several times and stayed with my family. He promised me, Lordship will take note, he promised me and my family as well to marry me. This is a promise to marry. He is staying in my home and me staying with him at his flat 6 Mile was a very common, as he promised me to marry. We were physically, now Lordship will come, we were physically and emotionally devoted to each other. Devoted to each other physically and emotionally, and our families were known to our bonding. And he promised me a conjugal life with me. Some of his dresses and mementos are still available in my home. We travel together, shop together, often live together. So, maximum a breach of promise, Lordship. Then, suddenly, since the last 1st, 2023. Lordship will take note. This is of 6/9/2024 affair. Affair is date and the top at page 34, Lordship. This affair is filed on 6/9/2024. Then, since last 1st of 2023, so-and-so started treating me badly. So it is from the last part of 2023. He started scolding me, assaulting me, and even threatening me to death when I tried to contact him. Then he wanted to break the relationship at any cost, even when our parents and families are involved. And I have emotionally and physically invested myself completely to him on the basis of the promise to marry me. It is the promise to marry me every time, Lordship. All of a sudden, he stopped contacting me totally and thus pushed me and my family to mental trauma, public humiliation. On 31st May, I suddenly, it is the complainant, suddenly visited his flat at 6 Mile with my hostel roommate. That day, he pulled me inside in a room and assaulted me. He put a pistol on my forehead and threatened me to death. When I tried to come out of his bedroom to the drawing room where my roommate was sitting, he tried to strangle my neck. I somehow ran away from his flat and saved my life.
This is not on the gun.
So police went to my home, looked for gun, everything has done. This all things are completed, Lordship. Even now, Lordship, all these things are going on, and I am on bail for last 1 year. Now, Lordship, may please come to page 145.
Objection. One 45 last.
Page 145.
Last.
It is their objection, Lordship. It is the last line of page 145, Lordship. However, it is the last line of page 145. It is there on oath, Lordship. However, since 2023, the accused person not only breached his solemn promise to marry respondent number 2, but also deceitfully banned her for another woman, thereby causing her emotional and reputational harm. That cannot be an offense, Lordship. Now, both of them are major. Now, out of jealousy, that he is going with some other girls and all that. These are the allegations, Lordship. I don't want to go to all this story, Lordship. But this is the position, Lordship. And what report my learned friend has given, Lordship will see. And this is the affair. It's a breach of promise, Lordship. Then he said that we were in love relationship. Then in 2023, I am not there. Then in 2024, there is an affair, Lordship. All these, Lordship, story, Lordship, I don't know. And I am on bail, Lordship, long 1 year, Lordship, now. That's my simple question. And I denied, Lordship, totally that I called her at any point of time after that. I not called her from 2023. She's admitting, and now why I'll call her, Lordship? So that's a story, Lordship.
I would like to point out to your lordship, my lord, in this case, my lord, your lordship has already perused the case diary and from the FIR, my lord. And from the FIR, my lord, your lordship, only I just tried to point out, my lord, one portion. My lord. On 31st May, I suddenly visited his flat at 6 Mile with my hostel roommate. That day, he pulled me inside his room and assaulted me. He put a pistol in my forehead and threatened me to death. When I tried to come out of his bedroom to the drawing room where my roommate was sitting, he tried to strangle my neck. So I'm just pointing out regarding other allegations if they are in the FIR. But on the basis of those allegations, on my lord 11/9/2024, my lord, section 307 against the accused person, my lord. And in this case, my lord, what happened, my lord, initially petitioner has approached before the trial court on 6/9/24, my lord. On that day, in fact, the Bhanagor PS case was not registered. This was registered on 8/9/24.
on that day, my lord, the trial court has, my lord, was pleased to grant interim protection to the present petitioner, my lord. Finally, on
Interim protection was
interim protection on 7/9/24. Thereafter, my lord, after perusal of the case diary on 21/9/24, my lord, the trial court has rejected the bail petition of the petitioner. Thereafter, my lord, the present petitioner has approached before this honorable court by way of the present, my lord, bail petition, my lord. And in this,
23/9.
yes, in this bail petition, my lord, this honorable court was pleased to grant interim protection to the petitioner by the order dated 23/9/24. And on 23/9/24, my lord, there is specific direction of this honorable court, my lord, while granting interim protection, my lord. Accordingly, in the interim, my lord, it is hereby directed that in the event of arrest of the petitioner, namely Sri Sankarjyoti Barua in connection with this case number so and so, the arresting authority shall release him on bail with one surety of so and so. The petitioner is directed to appear before the investigating officer within 10 days from today. Well, that is the specifically mentioned in the interim order passed by the honorable court on 21/9. Here, my lord, in the case diary, I have found the yes statement of the petitioner while granting interim protection by the trial court is there on 9/9. My lord, 24. His statement is recorded.
20.
9/9/24, my lord.
9/9/20.
9/9 he obtained interim bail on 7 earlier.
Mm.
Thereafter on 9/9/24 he appeared and his statement recorded. Thereafter, my lord, his bail petition is rejected on 21/9/24 by the trial court.
Yes.
Again, my lord, while this honorable court, my lord, on 23/9/24 granted interim protection, specific direction is that with the direction to the petitioner that he shall appear before the my lord IO within a period of 10 days. But thereafter, my lord, he never appeared before the. There is no statement of the petitioner. So there was the first one. He till now, after obtaining interim, he violated the order of this honorable court, my lord. And regarding the material, my lord, here in the case diary, my lord, statement of the 164 statement of the victim, my lord, 164 statement of the mother of the victim, and 164 statement of the FIR name, my lord, friend of the victim who accompanied the victim on that day, my lord, 31st May 2025 at the, my lord, flat of the accused petitioner at 6 Mile. His, my lord, statement is also recorded, my lord. And one medical report is also available in the case diary. And from all the, and my lord, I have already provided, my lord, that to your lordship on bail action, there is specifically mentioned the petitioner. This is not first case against the present petitioner. One Duliajan PS case is also there, my lord. And that Duliajan PS case is also, my lord, same kind of offense specifically mentioned in the your lordship. I have already, my lord, handed over that my lord bail objection order specifically mentioned, my lord, about Duliajan PS case. Now, my lord, although today, my lord, that copy of the bail objection filed by the petitioner is not with me, my additional affidavit, but I have gone for the court record, my lord. That my lord specifically mentioned that in that Duliajan PS case already ordered interim bail made absolute. Whether in that Duliajan case, my lord, interim order bail made absolute or not, my lord. In fact,
Where is the report? Here.
yes, my lord.
These are all absolute lawsuits.
all absolute. So admitted fact is that, my lord.
I have let him finish lawsuit while
So,
satisfied.
my lord, admitted fact is that petitioner is also involved in a PS case, my lord, involving similar kind of offense. My lord, whether he obtained, my lord, absolute bail or not, my lord, that is not material for, my lord, deciding the present bail petition. And present petitioner is a, my lord, influential leader at that point of time of ASU, my lord. And how, my lord, he, my lord, sexually exploited the present victim, my lord. Everything is there in the case diary from the statement of the, my lord, victimized, my lord, person, my lord, victim, her mother, my lord, her friend, my lord, everything is there, my lord, and medical report is also there. And more particularly, while the petitioner, after obtaining interim bail from this honorable court on 21/9/24, my lord, till date, my lord, he has not appeared before the trial court. And regarding that GD entry, my lord, now, my lord, they are trying to dragging the matter, my lord, unnecessary, because here, what is the case, my lord? Here, one FIR is there, and from this FIR, my lord, what are the allegations that victimized person was sexually, my lord, exploited, and thereafter, my lord, other allegations how he, my lord, treated the victim. In fact, while the
friend of the victim is also there at that point of time. All are these allegations. Later on, my lord, regarding that, my lord, he make one threatening call by way of WhatsApp or by any other, my lord, social media or by any manner, my lord. That will not otherwise reflect the decision of this to decide this anticipatory bail application against the present.
No, this will be an effect because he was on interim. There were some directions that obviously out of the other direction,
yes,
there are other directions also. He will not
Right.
threaten, supersede anyway to the other witnesses on.
Yes.
If he has already violated those conditions, if by threatening the victim and also, it will, it is
Yes, it
relevant.
will
It is
affect,
definitely
definitely, yes,
relevant.
it will
So
affect.
otherwise, we have this report is with us. So
Yes,
we
my
have
lord,
come-
regarding that, I am just trying to point out, yes, those will affect, but taking the matter by only by, my lord, on the point that those matters will require to be called from the WhatsApp and from, my lord.
This is their submission.
that
That
will
though the FIR was there, but there was no supported with any WhatsApp call, timing,
yes.
etc. Were not.
Yes.
That is just.
But otherwise, from the admitted facts is that, my lord, he not only this time, my lord, since earlier, my lord, threatening party is also there, and, my lord, how his friend's statement is also there, my lord. Not only at that point of time who accompanied the victim, and everything is there. And after obtaining interim bail from the trial court, in fact, on that day, my lord, on 7/9/24, case was also not registered. Initially, my lord, complaint was filed before the Bongagor police station, as because jurisdiction is of 6 mile. Later on, matter transferred to, my lord, Dispur police station. And on 8/9/24, case registered. And thereafter, my lord, while the learned trial court rejected bail petition on 21/9/24 after perusal of the
He did not
case there. And now admitted fact is that after, at that point of time on 9/9/24, while you are in interim protection, by way of the trial court order, he, my lord, appeared before IO. That is a different thing. Now, while this, again you approach before this honorable court specifically directed you on 23/9 that you should appear before the trial court within a period of 10 days. Then he also has not complied that order of the, my lord, this honorable court. And otherwise, from this, he is also involved in one another, my lord, Duliajan PS case. In this case also from the, my lord, statement of the victim.
So where from you are saying, Mr. Sharma, that
307
Duliajan PS, he got the absolute bail. Is there any mention regarding that?
The order is.
That is my additional affidavit also there.
Oh, additional affidavit.
Statement is there.
Okay, oh, we'll see.
These are my submissions, my lord, from the considering this, and, my lord, otherwise he is a very influential leader, my lord. He can, my lord, anyway, my lord, victimized person, how, my lord, how he, my lord, involved, how he, my lord, sexually exploited his victim, my lord. Everything is there in the case diary, my lord. These are my submissions. Your lordship may kindly close the case.
Yes, Mr. Mohan.
My lord, I file a objection. And regarding my lord, already my lord made it, my lord, here my learned friend submitted regarding my lord that case there also placed before your lordship. Definitely your lordship produce the case there, my lord. But only my objection is that my lord, he misused this liberty, and while he was in interim bail, he threatening me over telephone, and that's why I pointed out decision before this honorable court. Only on that ground I am before this honorable court, that I am just pointed out that for that effect I lodged an FIR. There is GD&T was there. And that's why this honorable court asked them to, my lord, what is the preliminary inquiry done by the investigation agency, and that has to be placed before your lord. Probably that is placed before your lord.
Yes.
So, my lord, necessarily, my lord, if well they are in my interim bail, misuse the liberty, then my lord, it is not entitled to get, my lord, bail, my lord, absolute bail, my lord. Your lordship kindly, that's why, my lord, what they have stated in the, my lord, inquiry report regarding the GD&T, my lord, that your lordship kindly go. That is my submission. And if they really violated, because I have stated on what I have lodged a complaint immediately, my lord. FIR and complaint, that is not the encyclopedia of everything. It is not necessary to, my lord, mention everything in the FIR and everything in the complaint, my lord. This, my lord, it is just put the investigation agency into motion. Put in motion, and they will find, they will place before the court. Probably that is they are to place before your lordship, and your lordship can do it. That is my submission.
So first come first, Lordship, I have given a copy of this. Lordship, the IO should not mislead the public prosecutor like this. This is very serious, my lord. You are in a criminal, Lordship, jurisdiction. Lordship, may please come to this document, 3 pages I have given, Lordship. Seal and signature is there of the IO. And now today they are saying that I have not appeared before the IO within 10 days, you see. Lordship, may please come. Lordship, get it?
Which was submitted?
It cannot be given away.
Whatever, yeah,
আপনি দিছিলেন নি কাগজখন চাই উঠলি আগতে অলপমান অভাৰ হৈ যায় Lordship, may please take my copy, Lordship.
This is the order. This is not,
Lordship, no, this is the copy, Lordship.
you have annexed it with your objection.
No, Lordship, I have given just now, Lordship, that they have received my, yeah,
Received your?
that I have appeared before the EA, Lordship. Along with this letter, I went to the police station with the court's order. I have annexed the
with this
court's order.
letter?
Yes, and then Lordship, the police station has received and give this seal. And the public prosecutor today, Lordship, saying that I have not appeared within 10 days. Unfortunate, Lordship. This is, I have nothing against my land train. The public prosecutor. See how the IO has misled the public prosecutor. He took my statement, Lordship. I appeared, I am there for 3 hours, Lordship, on that day. Then I am sitting there in my, in the police campus, Lordship. They send the police officer to my home. And there was a search at my home. Second day, calling Lordship for the gun. And this is the statement today before the court that after the court order, I have not.
Before you appeared on 24/9/24 at about 11:25 p.m.
Yes.
My lord, your lordship may kindly, my lord, pick this matter tomorrow or day after tomorrow, my lord, regarding that.
That is the EA, Lordship. I know. For last 9 months, this is going on, Lordship. I know.
Trying to bring the matter, my lord, tomorrow, my lord.
I know.
Well, because I have not found any statement in the case.
If Lordship, this seal is wrong, then I'll go out. Why, Lordship, always this time? I have given a copy to him, third page.
No, I have got this copy, my lord.
There may be two.
There should
I
be
don't
some
know.
limit of
Exact-
misleading the
exact
court,
one,
Lordship.
You may correctly submitted, Mr. Potter, that their statement may not be available.
Yes.
But the question is that he appeared before the IO. I don't know. It seems to be that he appeared before the IO on 24/9/2024 with the copy of the order, with a separate application.
Yes.
And I have
Which I have
informed
seen
that
this.
court has passed this order, look into it. I am there for 3 hours. The police officer gone to my home, searched, coming back, then said, okay, go.
But the question is that Mr. Potter is pointing
Sorry, my
out,
lord,
not
definitely,
otherwise, but
the-
he is pointing out that their statements are not available. On 9/9 you appeared.
Yes.
After getting the interim, your statement is
Yes.
there. But after obtaining the 23rd of September, when he appeared his subsequent interim from this court,
Again,
no, then you have not appeared.
No, I
None, that is the
I have
question,
appeared,
your
Lordship.
statement is not available. Is
no,
it,
no, he said your statement is always, this is
No, no.
24/9. I again
no,
appeared.
9/9 statement is there.
Yes.
After 23rd.
Yes, I went there. I see, this is 24/9, Lordship.
No, that is understood. I'm not on that. Now, he is saying that after 23rd, after opening of the interim, you have not appeared because your statements are not available after 23rd. That
But
is.
this is my document, Lordship. Luckily, Lordship, I keep this. Otherwise, I'm in trouble today. If this is the way, Lordship, the
My lord,
official
sorry,
is being
this may
done,
be
I'm
my
really
mistake,
sorry,
my
Lordship.
lord. That order, my lord, I have not found. I have found only the statement recorded on 9/9/24, and regarding that, my lord, I have also.
This is something misleading the court,
For
Lordship.
better clarification, my lord, your lordship may kindly fix it tomorrow or day after tomorrow. Regarding only for clarification of
It
that
is a,
aspect. Otherwise,
what to clarify, Lordship,
otherwise, my
the
lord, if we
document
appear,
shows,
then
Lordship.
also, my lord, I am pointing out to your lordship regarding the materials, my lord. Against the accused petitioner, my lord.
Yeah.
On that aspect, only for clarification, my lord, whether he has appeared and if there is any statement recorded, I need that statement, my lord. After, my lord, 20, or if not, my lord, IO has not recorded any statement also after 9/9/24, but he obtained the order of the High Court and he appeared, that also I will clarify, my lord. Regarding, but from the case diary, my lord, otherwise, this is a matter is serious, because, my lord, if, my lord, I have made any wrong submission and, my lord, without properly verifying, that will also otherwise, because I am appearing on behalf of the state. So, my lord, my fear, I may be, my lord, sometimes, so, my lord, I need clarification, my lord, I need to get clarification from.
How is it material, my lord? I have shown Why all this? Yeah, I do not know, Lordship. That
Every
will
way
be-
they
Anyway, Lordship, let me finish my part. Lordship, my petition. Lordship, may please come to page 17. Let me finish my argument. Lordship will
1-7.
my application, Lordship. My AB application 2579/2024. The second slot of argument that my AB application was rejected. So, Lordship, may please come to page 17.
Yes.
Page 17, para 17.
Yes.
That by final order dated 21/9/24, the learned session court rejected the first petition. The following table quickly summarize the reason of rejection of the first petition by the learned session court. So I have summarized what is the ground and why he has rejected my petition. Lordship, this is something unheard of in the criminal jurisprudence. Lordship will go through. What consideration he has rejected, Lordship will go through it.
Right. We need to do.
Lordship, only one, Lordship, let me read one, Lordship, for Lordship satisfaction, page 18. In the para 9 at page 7 of his order, A, Honorable Appeals Court interim and the final order SLP in criminal so-and-so are distinguishable. B, investigation in the instant case is at the nonsense stage. It is an affair of 6/9/2024. Then, merely getting statement recorded, Lordship will see this. Their intention, Lordship will see this. Merely getting statement recorded at PS does not mean the petitioner is cooperating with the investigation. So I have to confess. This is the rejection ground of a session judge.
I think we were.
This is of where from? This one, session judge.
Guwahati Lordship. Unfortunate Lordship, and I have shown 7 to 10 judgment from Arvind Kejriwal to everything, nothing. And these, after going through all this, he said he has not confessed that he has a pistol in his hand. So only statement, giving a statement will not do. You have to confess that you have a pistol in your hand. That is, then only the statement is completed, according to him. So this is the ground, Lordship, and that is why I made this start. Because from the judgment reading here and there, Lordship, I have given the para, I have given the page, and I have given on what ground he has rejected my bill. Then, Lordship, and page 19, what I have said regarding the arms, Lordship, page 19. Para 13, page 13 of his judgment, Lordship, B, small b. Custodial interrogation of the petitioner is necessary to unearth the facts regarding the possible use of unauthorized arm by the petitioner.
You want me to confess?
So you want me to confess under the custodial.
That is not your purpose.
Now it is according to him, jail is a rule, Lordship. Bail is not the rule according to him, Lordship. So this is my Lordship, and the Lordship, my document is very clear. My learned friend is there, so my learned friend is argued and has shown the year. So he will show something and say that the after 2 days, after 3 days, whatever, Lordship, whenever he want, Lordship, I don't mind. I have shown my.
I am extremely sorry, my lord. Yes, in this case, diary, my lord. After, my lord, regarding that, I am clear that after 9/9/24, statement of the, my lord, petitioner is not there in the case. But your lordship may kindly peruse the, my lord, bail, that report of the IO and bail of this one. It is specifically para number 5 serial number. It is pertinent to mention that the accused had commissioned the aforesaid crime height so and so earlier than PS case number edit section so and so. While he has been going through interim bail period granted by honorable court in connection with this case, by this full PS case number so and so edit section 307 IPC, this vehemently shows that it uses a heavy. So, my lord, from this it reflects the yes, my lord, and this while my learned senior has, my lord, handed over this copy of the, my lord, this. So, my lord, he has now he has appeared, but his statement is not there in the case diary after 9/9/24. That after
So what
obtaining
kind of clarification do you want now at this stage?
Otherwise,
regarding the clarification.
Yes,
clarification
Lordship,
that he had-
even Lordship,
my lord, whether any further statement recorded by the IO, I will clarify to that aspect. And
or
regarding-
If-
whether
even
why no
Lordship can-
statement was recorded.
Yes, yes.
even after the Lordship absolutely interim order, Lordship can always say that I have to cooperate. Any date, Lordship, they will go, I'll go there, Lordship. It is not that if in the interim I'll go there. Even Lordship will make the order absolute.
But in
Then I
regards
have to
the
cooperate.
threatening part, what do you want to submit in regards to the threatening part as they have raised the issue?
No, I know, Lordship,
The-
they let them clarify whatever they.
No, not clarification regarding the part of the
All to what?
objection filed by.
I
the
said
government side.
no, my lord. That is why on oath I have filed this affidavit, Lordship. I said no, my lord. From 2023, I have no connection.
And as per you, after obtaining the interim bill, this threatening part is there.
Yes, my lord. That's why my lord, I have attached my,
Report
my
is
lord,
there,
that
yeah.
which is my lord registered.
There is no call log, nothing.
So that would be the duty of the my lord investigation officer.
Exactly.
It is not my duty to, everything has to be mentioned in the FIR, my lord.
No.
I know it is.
Then they will, my lord, suppose my lord, I file a complaint, that complaint, nothing get my, then he will place before dishonorable court, my lord. That's why, my lord, dishonorable court asked the report from the IO, my lord. So your lordship kindly, but whatever
yes,
report I do not know, my lord, I am not supposed to know, my lord, but that is but be placed before your lordship, my lord.
So, my lord, regarding other parts, my lord, my submission is clear, my lord. Now, my lord,
Only clear.
only that clarification whether after 9924 any statement recorded by the.
And if not, why not?
Otherwise, my lord, whatever materials against the accused person's statement of the victim and medical report, everything, my lord, I have already pointed out to your lordship. And if your lordship want, I can also, my lord, hand over the case diary or.
I'll part, I will dictate the half part.
And regarding clarification, my lord,
Regarding
tomorrow I will
clarification,
clarify your
it will be
lordship
there, so
whether
it
any.
will depend on the partner, you can hand over the case diary, maybe by
And if
tomorrow.
any statement recorded by the IO after 9924, I will collect it and hand over to your lordship, my lord. That may be taken as a part of the record. And if not recorded after 9924.
How can you, how will you obtain those, your thing?
My lord, I will.
So what, you get it fixed by tomorrow or day after tomorrow, when you want?
Tomorrow I will get the instruction, my lord. Day after.
Instruction if you get, you will get,
Day after.
but regarding the furnishing of those statements, if recorded,
Yes.
can it be, will it be
Day after
possible?
tomorrow, my lord. Day after. At 2 PM I can, my lord.
Otherwise, the rest part, you no need to submit, I have already recorded. I'll pass the order. You
Let
want
me
to
listen, I
submit
do not
anything?
know whether this document is there in the record or not. At least I keep my I do not know whether they have kept this on their record or not. Because I have specifically written a letter that I want to give a statement, that is why I am here. And 3 hours, Lordship.
They have not recorded it there.
Not 10 minutes, 15 minutes, 3 hours.
CCTV recording service.
I'll dictate this one. Half month to test this part, you will submit.
Let the CCTV record be called for from the police station. Let us see whether I am there or not.
Admitted fact is that, my lord, yes, he appeared. Now I'm not saying that he, because in that regard, my lord, because I have not found the, my lord, statement of the accused person, my lord, and that copy, my lord, that's why I'm at that point of time, my submission is that he has not appeared.
So luckily, I have this document, so at least my appearance is clear. And now, if the statement is not there, again they will say that I'll go for statement. That's it. And the statement can taken through it to the dustbin.
Just clarify one more thing. He was on interim since 23rd of September. But thereafter, why he, I mean, as per you, why he threatened the girl? Why
My lord,
threatened the
that is,
victim?
my lord, that is, he should know, my lord, why he is threatening the girl, my lord. Because, my lord, because I do, because not, then, my lord, your lordship can question him also here, that, my lord, while he is in interim bail, my lord, he is arrested in another case, my lord. Why he is doing that, my lord?
I'm not
He was-
doing that. That is why the court has given bail.
He was arrested, my lord.
In another case.
Another case, my lord.
Yes,
After,
yes, yes.
while in interim bail of this case, my lord.
Yes.
While he was in interim bail of this case, my lord, he was arrested in Dulias and Puis case, my lord. He was in jail, my lord.
Lordship, in the High Court's order, it is written, Lordship, that arrest is against the Constitution, Lordship. It is written.
The interim.
Just to victimize him, Lordship. It is very specific, Lordship. that it is against the constitutional lordship, the arrest of the petitioner.
That is their concept. They are trying to rely on each other.
And that is, that they are trying to rely on this lordship arrest, so that is why I have said simple line.
Your
Lordship, may please
interim-
come to para
in
20.
Duliadan, your interim granted on 26/5 and then it was made absolute on 56.
Yes, both the order, no, yes, sir. Both. I've given
Yes,
the
we have
absolute
given,
order.
yeah.
So Lordship, in para 20 at page 7 out of 8. However, in the meanwhile, considering the fact of the case in so and so was initially registered under so and so, was served on the petitioner, his relatives under so and so, also contains information regarding the bailable section only. Further, the forwarding report of the petitioner in correction of so and so mentioned that the offence was registered under so and so bailable only, and apparently it appears that prima facie some procedural irregularity appears to be committed in the allowing the so and still arrival of the so and so.
You arrested me for bailable.
You say in a bailable offence you was arrested, Lordship.
Alleged bail.
And Lordship, this court has recorded that. Not only in the interim, in the final panel, they want to rely on that case, Lordship. Anyone,
Relying on the conduct of the my lord, his conduct I am placing before your
and
lordship.
this court has shown the conduct of the police. This court has written the conduct of the police in the court's order.
Lords. It's illegal. Conduct of the-
Conduct of the police should come in all the order like this, Lordship. How the people are behind the bar. Because today's thing, Lordship, what the IO has sent to the PP, one should be recorded, Lordship. Then lie will come out.
My lord,
How the
IO has submitted that report. My lord, in that report also, I pointed out to your lordship, from that it reflects that he has appeared, my lord. That aspect, my lord, probably, my lord, that is my lord, maybe some, my lord, I have not done for that portion. That is serial number 5. From that serial number 5.
But
Report of the IO.
From the
one
report of the
person,
IO, my lord, that is, it is pertinent.
my
to
client
mention that-
cannot be harassed like this. It is for their fault, Lordship. I am going to the police station once, twice, and they are not
He has been,
taking
while
my
he has been
statement.
going through, my lord, interim bail period granted by this honorable court in connection with this 5 school PS case number, so and so, I appreciated 6. Oh, yes, my lord. From that, my lord, it does not reflect that, my lord, he appeared, so I will get the instruction behind.
Yeah, equal. Once he's saying I've appeared, once he's saying.
It is stupid. Take the names.
Luckily, I kept that document, Lordship. Otherwise, I am in trouble today.
It will be a part of the document record. You want to get it back or what, Mr. Sharma? You want to get it back?
Lordship.
What do you want to?
Lordship.
No, you get it back from here, no what?
No.
No.
We have a copy.
What do you have?
We have a copy. No. I have given a copy to him also.
So regarding that portion, that, my lord, he has not appeared, I am withdrawing that submission, my lord.
Okay, I'll dictate it, some portion of the dictation and then you will listing it day after tomorrow.
Yes, ma'am.
List.
I am handing over the.
Your interim will be extended till day after tomorrow, you think? Huh? Please. Based on 30. Don't make further submission because I have already recorded all this.
2 p.m. Lordship. He said 2 p.m. Lordship.
At 2 p.m. on 30th at 2 p.m.
At 2 p.m.
Otherwise, don't make further submission.
No.
because I
That is why I have finished my argument, Lordship. I don't want to.
I will only point out, my lord, whether any statement
Sure.
after
Please
9924.
take for DD. Or interim be extended till next. Okay.
On
30th at 2
that,
p.m.
my argument is clear, Lordship. If they
No,
have
I
not,
have already recorded.
not
You
here,
put
the statement is not recorded, is there for Lordship. I have visited twice. I am there in the police station once in the 3 hours, the next day more than 1 hour.
Okay.
I am grateful.
CD, you are going to, CD is with you. Any
No.
further submission from on, yeah,
Oh, no, my lord, city, my lord, I have already handed over.
You have handed over,
Yes,
can hand
yes.
over.
24 May I please, your lordship? Lordship, this is a very long pending case, my lord. Since March 2025, I am on interim. I appeared, my statement recorded, there is nothing remain, lordship, in this case.
24, my lord, charge sheet submitted in this case.
No, it is বন্ধ করলেন কি করে? কি দিব নালাগে তুমি এসিটো বন্ধ করো বন্ধ ইয়েস ফ্যানটো
May I please, your
Yes,
lordship?
Mr.
As
Swain.
per my learned friend, told the court that the charge sheet has been submitted. I was in
Already charge
interim,
sheet?
my statement recorded,
Item number
lordship,
24, my lord.
and lordship, if charge sheet submitted, then I will appear.
Charge number, case number
Charge sheet number 118/24,
118/24.
24, my lord. Dated 39/20. Again, arrested accused person Mukesh Sharma.
39/24 and
Yes.
till that he was not I don't know.
Yes, your lordship may kindly take this report as a part of the record. ma'am. Oh, no,
Part Mr. is somewhat in an consultative part Mr. He bought a additional 50 appeal. It was for his diary but submitted by Mr. Porter. The case has already been charged with CS number 118 of 24 dated 39 to this context, in this context, Mr. Somwa, the learned counsel for the petitioner, submitted that petitioners were on interim and they have already appeared and cooperated in the investigation. Considering your interim prayer we are extending for 15 days. Appear before the learned trial court below with a regular application for bail that may be considered. Otherwise, we are extending your interim till 15 days.
Lordship,
Till 15 days, we are extending.
it may be for 1 month, may it be for 1 month. Lordship.
1 month? Why? What is the urgency? What is the case?
No urgency because communication gap is there, because this case is right now I am not in communicate with the petitioner, so I have to.
But you are appearing.
Yes.
If you are appearing, you must have some communication. Try to get it.
Make it
because-
20 days, lordship, 20 days. Within 20 days, I will.
Okay.
Problems.
20 days quitting. Okay, we are extending.
Problem.
And
Deeply
if
obliged.
kept of the cast recording, the report received from the IO, we kept as a part. Okay.
But in this matter, my lord, petitioner is already on
My
interim.
lord, case diary not received. ma'am. Petitioner is in interim. ma'am.
Not received.
Not yet.
City not received. Should remember. Yes, when can be?
On my lord, 9th of September.
9/9 ready. Interim be extended till next year.
Highly obliged.
26.
May I please, your lordship? Lordship, earlier interim granted, that is what itself.
Here, what is the position? We have received the case there.
Yes, my lord, in this case diary, sheet already submitted, my lord.
Yes, submit.
Number 25, dated 28/2/25.
You were on interim earlier,
Yes, interim.
same order কৰিব. You are Mr.
Mr. P.K. Das.
Hard Mr. P.K. Das. Baকি Hard Mr. Bhattakur, same order থাকিব. CS number 42/2025 dated 28/2. We are also extending your interim till 15 days.
Close.
Make a regular application before the London.
Obliged. Obliged.
Disposed.
May it please, Your Lordship. Here, my lord, the case diary along with my lord, medical report was called for, my lord. Medical report, I can. Earlier, my lord, CD was there, my lord, but since my lord, medical report was not there, my lord, it was my lord returned back, my lord, with a direction to my lord, call for the medical report. In many occasions, my lord, Mr. was listed, my lord. Okay, my lord, FIR lordship will find at page 8, my lord.
We have received the case diary today.
The case diary received, but medical report not received. One medical report of Sonapur, my lord, medical and health center is available. Patient came with previous injuries and was referred to GMCS within 10 minutes. But thereafter, my lord, injury report from GMCS, my lord, requisition is there, my lord, in the case diary, but that injury report not yet received.
Case was
Which was
registered on
document-
1181 and 1182.
Lordship, my lord, basically.
Previous, sir.
Lordship.
Previous, sir.
Yes, sir. And
So your
অনিল সিঙৰ দশমৰ প্ৰতিবেদন GMCS ভঙাগড়ৰ পৰা বিভাগীয় ডাকযোগে সংগ্ৰহ কৰি
any description of any injury is there? Is there any description of injury? No.
sorry my lord, in this case GMCS also, my lord, injury report. GMCS. Yes, my lord, one report received from GMCS. Simple from surgery side, my lord, it is still mentioned that opinion simple from surgery side. Final report to be collected from neurosurgery department. Again from GMCS. That opinion, my lord, that is the note of the IO, my lord. এতিয়া এই মই মোৰ জখমী অনিল সিঙৰ জখমৰ প্ৰতিবেদন GMCS ভঙাগড়ৰ পৰা বিভাগীয় ডাকযোগে সংগ্ৰহ কৰি পঞ্জীৰ লগত পৃথকে লিপিবদ্ধ কৰি ৰাখো। আনহাতে মতামত তলত উল্লেখ কৰিলো opinion simple from surgery side, final report to be collected from neurosurgery.
Obviously, the question is that he may sustain injury on his head,
Yes,
it's simple.
backside, or
Yes,
wherever. As per the wound, or if you can't submit that may be a simple in nature.
Yes.
Suppose laceration,
Yes.
or suppose there may be some sort of injury with 4, 5, 6 stitches may be required.
Yes.
But the question is, what about the neurosurgical?
Yes, well, that
is
is
the
not there are materials again the
And otherwise, my lord, so far my instruction, my lord, simple injury was caused, my lord, and that too, my lord, from the FIR itself, my lord, it appears, my lord. I am a, my lord, in charge of a, my lord, coke company, my lord. And in the campus, my lord, Iskabul has taken place between the petitioner and the security guard, my lord. And since I was present, my lord, I went there, my lord, I resisted the security guard, my lord. And the informant is a, my lord, a person outside of Assam, my lord. And since, my lord, and the petitioner as well as the security guard is from, my lord, local person, my lord, while, my lord, filing this FIR, my lord, my name is was also inserted, my lord. And so far my instruction, my lord, only simple injury was caused, my lord.
Bhattakur, let him appear and cooperate in
Lordship.
the investigation.
Yes.
In the meantime, you may call for, because the case, now see, several days have been gone for this
Yes,
report.
yes, ma'am.
We are not going by detail of the merit of the case.
Yes.
Well, we
Yes.
may call.
Yes.
Heard Mr. K. Bodma, they done it counsel for the petition. And also heard Mr. P. Bodma, they done in addition to the agreement. With an application, section 20. Next, but I just submitted by Mr. Bodma, that's CD received, but the medical report is not available in the medical report of the injury report is not available in the case there. So, the opinion of the TMC is reported by the IO, which reveals that from the surgical side, the victim sustained minor injury, but the matter was referred to neurological department. Mr. Borwa, the learned counsel for the petitioner submitted in this regard that the case was fixed for several occasions for case diary and the medical report. Till then, the IO could not collect the medical report. Accordingly, he submitted that some interim protection may be provided to the present petition. How many petitions you have?
One.
But considering the entire circumstances of this case, I find it difficult to extend the privilege of interim real estate to represent petition till receipt of the updated case diary along with the petition. But in the okay, you'll be some if you have some interim.
Some protection.
Appear before the IO, cooperate in the investigation, and
Right.
then after perusing the medical report and documents, you file. Yes, what approved when it
On my lord, 9/9.
we're fixing it on 9/9. We're calling for the updated case there and for the, along with the medical of the injury.
Dream was provided by.
Okay.
Good. Oh. What happened? Brought directly here.
Yes, but this is was called for.
You want Metal?
20.
Oh, no.
20.
28.
20 month CD of receipt, my lord.
We are on internet.
CD not received. CD not received. So depend. Yes. When?
Any date matter. After my lord, 15th.
If of it.
Yes.
After no, maybe in the first week of September also.
Yeah, then my lord, it is yeah, my lord, 8th of September.
It can be extended.
Please, your lordship, earlier CD was been called for.
Here, my lord, search it submitted matter in this matter.
Oh. CS number?
My CS number, my lord, 41/2025, dated 17/7/2025.
You were on internet?
We get a communication. Make it part.
You are Mr.
J.A. Sigdar.
Heard Mr. J.A. Sikdar, the learned counsel for the petition. Also heard Mr. K. Busher, the learned petitioner BP, appearing on behalf of state respondent. This is an application, and it's no like. Case was fixed for case diary. And it is submitted by Mr. Waterford. That case has already been charged by CS number 41 of 2025, dated 17/7/2025. And in view of this, petitioner hereby directly appear before the learned court below with a regular application. It may be considered 15 days. You are on interim, so your interim, we are extending your interim till 15 days. 15 next 15 days, appear before the trial court below with a regular application copy.
Item 30 also, my lord, interim was there, my lord, but CD not received.
CD not received. Issue reminder. Yes, when it can be.
4/9.
4/9. Interim be extended till next. We're extending your interim.
My pleasure, lordship.
234 CD received.
Yes.
In this case, Lordship, two case diary was called for Lordship as per earlier order, Lordship.
One
Case diary.
present case diary received, my lord, 234/25, but 236/25. Okay.
One is 234 and one is 236.
236.
Your case is concerned with
Lordship, we are apprehending areas in connection with 234, but
234. That has
236,
already been received.
236 is also required, Lordship, because 2 minutes, Lordship. Because, Lordship, there are two FIR, Lordship. The allegation is very much serious, Lordship. We are named in the FIR, Lordship. We are the brother and sister of the deceased, and 234 FIR lodged by the wife of the deceased, and the 236 FIR number 236 is lodged by the mother of the deceased out of the same cause of action, and the disease is our brother, Lordship, the petitioner's brother, and Lordship, in both.
Petitioner's brother is the deceased.
Yes, Lordship.
And who lodged FIR against you?
Wife of the disease.
Acha, why?
And 236 out of same cause of action, mother of the disease. And that FIR, mother of the which is lodged by our mother, the allegation is given against few other accused persons, against whom the disease has already on dispute since last few years, Lordship, and case is also pending.
But
That-
why the wife of the deceased suspected you?
Lordship, I don't know, Lordship. And Lordship, one another thing, Lordship, we have also annexed, Lordship, one screenshot of the CCTV footage, Lordship, and of a shop. And we have given the 65B of Evidence Act certificate also from the owner of that shop, that at the relevant point of time, Lordship, when the alleged offense was occurred as per FIR of 234, the victim was present at the shop, and which is 7 kilometers, which is 6 kilometers far from the place of occurrence. And at that time, time was about 8 p.m. and at that time the victim was present at that shop. She is located at that shop, and she lodged in the FIR that she have seen us at around 8 p.m. Committing the offense. That's why, Lordship, both the FIR was called for, since the mother of the disease is also important. That FIR is also important, and investigation to an extent may.
It could be, yes.
My lord, I am from my informant's wife, my lord.
Why?
Yes, my wife. But these facts is that the deceased Moniruzzaman is killed, murdered. It is the second FIR also, first FIR also, second. But-
Dispute is not there that he.
Yes,
there was a
secondly, my
homicide
lord,
in there.
that this petitioner is habitual offenders. They are deals with drugs, then cattle smuggling and murder. Everything is there. But subsequently, this FIR is filed by this mother under influence of this accused, because they can take the plea of alibi, my lord, alibi, and there are cases that only that some of the instances, some cases are pending against them. I just want to give. And
No,
another thing, my
it's
lord,
okay, they are habitual, some habitual.
Yes, yes,
There are, but why they kill their own brother?
my lord, they are my lord,
No,
for
yes, I
last,
can understand they are,
Yes.
things are there, but why they kill their own brother?
and might be some secret is known to them, him,
Some
or something, some others causes, but they are habitual offenders. 302 is pending against them, this petitioner. And secondly, my lord, these weapons, as per the FIR, through which this killing was done, that was not recovered by police. Only bamboo stick is recovered. If they are given at large in my lord pre-arrest bail, police may not recover these things, my lord. That is the key. But seizure list suggests that the weapons are not recovered.
So,
They are
is there any, I mean, if we call for the other case record?
But same, because my only submission is maybe to take
No,
the
no,
plea of
they are
alibi.
submitting that the mother of the deceased also lodged an FIR.
Yes,
There are two FIR, one is lodged by
wife
the
says
wife of
that,
the deceased,
yes,
just the second wife of the deceased, and the other one is the mother of the
subsequently mother.
whatever, mother of the deceased also lodged one FIR.
Regarding the killing of his son. Same
Yes,
person,
obviously, yes.
same person. But here some twist is there that
Definitely, he is asking for the other one. Two
some-
FIRs have been
he
lodged,
says that
one by
some
his
other
wife,
person,
one
not
by
this-
mother.
Yes, that is his. But thing is that these are the habitual offenders, not that criminal antecedents are present against them.
Yes, Bhattakur, what do you want?
Yes, otherwise, yes, from the material in the case, there is FSL report not yet received. Otherwise, there are eyewitnesses is also there against these accused persons. My eyewitnesses also implicated. And from the
So
of the IO,
we
it
call
also.
for the, wait for the, because there was
Yes,
an order,
yes, ma'am.
236
Yeah,
was also
yeah,
called for.
because her mother has lost the affair. so-
Lordship, the thing is, the first FIR, wife had said she has seen us, and on the other FIR, mother has said that she has seen the FIR name, other FIR name accused persons to committing the murder of his son. That's a fact. She has also stated that she has seen,
Otherwise,
and
out
the
of
and CCTV.
Fact of murder is confirmed, but who was the murder?
And Lordship,
They say
maybe other witnesses are also maybe available. We don't know about that, Lordship. And Lordship, page 24 and 25, Lordship, the screenshot of the CCTV footage, time is stated 7:57, 7:57.7 p.m. And she lost the FIR, which is at
these are habitual
Lordship,
officers, my
which is at page 14. 7:57, she was present at the shop, which is 6 kilometer far. And in this FIR, she stated the সম্মানপূর্বক বিনীত নিবেদন এজে আজি ইংরাজি 21/5/2025 তারিখ সন্ধিয়া অনুমান 8 মান বজাত.
last.
That both time are same, Lordship. But she cannot be present at the same time in two places, which is far from 6 kilometer, Lordship.
Last portion of the note of the IO. Why am I date during investigation? Out of property, my lord.
Property dispute. Okay, then can it be fixed on some other day, because we'll keep this case diary, we cannot keep,
Yes.
but the other case diary is of same police station, I think. This is 236. That what it may not be called for. But it was written here 17/7 called for. 236. 236 was also called for.
Yes, ma'am. 236 was also confirmed.
No, no, here why notice there? This is your note. Look at.
Oh, yes, my lord. This is my our petition, my lord.
Right.
Lordship, since today is the third date, Lordship, and the petitioner number 4 is a lady diabetic patient. I'm seeking protection from only, I'm pressing only from her. Petitioner number 4, I'm not pressing, since the allegation is serious and we are named in the FIR, Lordship. But petitioner number 4, Lordship, the lady, 49 years, she is a diabetic patient. Today is the third occasion.
49
He may
years,
be-
so young ladies can manage.
He- he may be allowed
nothing
to-
to worry about.
Third occasion, Lordship.
Hmm?
Today is the third occasion, Lordship. For city.
Third occasion. You
Did
can
you receive
dispose of the
otherwise,
matter
my
on
lord,
234, you are saying that 234
If my
is
lord,
also required.
my lord, delay is because of him, my lord, because otherwise if he is not present, that 236 is also required. Otherwise, from the materials available in the present case diary also, there
Can
is
be
a
disposed of.
In the
For
first
my-
order also, that is reflected, Lordship, that 236, the first order also.
Mr. Kita, that concept of petition.
This point of time, he is no right
Report.
to-
Put it on it. Mr. MJ Bur. MJ Bur. Appearing on behalf of Mr. Ganpat, appearing on behalf of Mr. Informant. CD of Oripur PS case number 234 of 2025 has already been received. But in that context, Mr. Thakur submitted that the Oripur PS case number 36 of 2025 was also called for, which was caused by the murder of the deceased of the murder of the present victim. 2 CD may be required for the disposal of this. From the record, it is seen that both the CDs were called for, but inadvertently only CD of Goripur PS number 34 25 is received. Received. Further, Mr. Purva, the learned counsel appearing for the now you are for the whom now you are?
Informant, wife.
Informant of the wife of the deceased. Subjected, submitted is submitted the bail of submitted some document.
They are habitual offenders and
Submitted that they are the habitual offenders, and in that regard, he also submitted some of the documents along with his written argument. Keep the same with the case record. Next part, case diary of Koripur PS case number 34, 2024, 25 being returned with calling updated one along with Koripur PS CD of Koripur PS case number 236 of the will be the statement.
On my lord, 11th of August, 11.
Yeah. Yeah, no, it will be on 14th then, because 11th there are
19th of August.
19th.
14 may be fixed, my lord.
14. 14.
Date published.
Okay.
CD was called for lordship. And also in this case, the petition number 2 was on bail lordship. Interim
Who
lordship.
was on bail?
Two.
Interim.
Interim lordship.
Who was on interim? One was not.
One was. Actually, FIR was registered under lordship section 80 of BNS lordship, and petition number 1 is the husband lordship, and 2 is the lordship mother-in-law lordship.
80 is what? It is earlier 498 or
Yes.
Earlier 490, yes, lordship, dowry debt lordship.
dowry debt 304B.
Yes, lordship. No, earlier this one, now lordship 80 BNS lordship is similar lordship.
Oh, it's a dowry debt.
Dowry debt lordship.
Oh. So one is husband or
One is husband lordship, and
husband is number 1.
number 1 lordship.
And number 2 is the mother-in-law.
Mother-in-law lordship.
So you are saying that mother-in-law was an interim.
She was on it. FIR is also page 15 lordship. This is the particular.
FIR is at page.
Page 15 lordship, particular. Yes. Yes.
Conclusive report is not there.
Yes, one PM report. itself is given.
Anyway, what are the other things?
Otherwise, my lord, statement of the witnesses is there regarding that, my lord. Otherwise, my lord, maybe custodial, my lord, regarding that, my lord, demand, the witness is there. There is, my lord, regarding harassment is there regarding. statement of the witness.
No, hanging part, no one has seen. You
Yes.
can understand, but
Yes, suspected, my lord.
Suspected lordship, then nothing is there for it.
In fact, on the earlier day also, my lord, there was some couple between the husband and wife regarding that. And after next day, it wife has come.
Phone call was made by the husband itself also to the family members of the wife also.
Strong suspicion is there, my lord.
otherwise it's a case that lady died. I mean, maybe they may commit suicide also, but in that case also, there are some allegations of the demand of dowry as well as some mental pressure to give birth a child.
Yes. Yes.
That
Those-
is
That
there.
allegation is there.
The allegation is there,
Witnesses
lordship,
also-
but
Witnesses also, my lord, supported that allegation.
So number two can be provided with, I think.
Yes.
One may not be at this stage. Let further report and all, they may approach. Because the lady, she died, in fact, in the circumstances and suspected, I mean, suspicious circumstance. Otherwise, what is your submission?
Well, because this is an anticipatory bail, my lord, considering the witnesses implicated the present because petitioner number two, my lord, already he obtained interim protection. And regarding that, two, my lord, but he is the husband and within, my lord, not it is, my lord, within 7 years of marriage, my lord, in a very short span of time, my lord, after marriage. And regarding that, my lord, physical and mental harassment, there is also, my lord, regarding that also, my lord,
Yeah, there are some.
implicated. Any husband, my lord,
Part study not. Part is to be done in addition. This is an application to inspect. City receipt. It's submitted by Mr. Nath that the present FIR has been launched only on suspicion and after the date of the deceased. They have not committed any such offense as in the FIR, nor there was any such demand of dowry from the petitioner side. The petitioner number two was already granted with the privilege of interim pre-arrest bail, and accordingly she appeared for the comma, cooperated in the investigation, and her statement is also recorded under section 183. the post of the petition number 1 is also ready and willing to cooperate with time if he is granted with the privilege of the arrest. Mr. Court, you done it. This shall be submitted in this regard. That there are sufficient incriminating matters against the present petition number 1. And petition number 1, however, the conclusive medical, the cause, the postmortem report regarding the cause of death is yet to be ascertained, and the viscera has already been sent for examination. Yes. But considering the statement made by the witnesses and the allegation brought against the petition number 2, it is objection in granting privilege of pre-arrest bail to the petition number 1. On snake there is submission made by any constitutional is record its diary. Considering the entire aspects of the case, materials available in materials available in the case diary, I find that this is not fit case to extend the privilege of pre-arrest bail to the petitioner of the petition number 1 of the husband of the deceased. However, considering the conduct of the accused petition number 2 and other materials in the case, I find that custodial interrogation of the petition number 2 may not be required for the investigation. In view of this, the order of interim pre-arrest bail granted to the petition number 2, namely so and so, by order dated 12/6/2025, is hereby made absolute with same terms and conditions, and the prayer for pre-arrest bail to the petition number 1 of the husband of the deceased is hereby rejected at this stage. The above observation. None appears on call. The petitioner. CD not received. CD received. Not it's not. CD not received. Issue reminder. Was there any entry? Oh, they are on interim.
No, no.
No.
The interim is there, Lord. Interim is there
Huh?
on 12/6/25.
Interim be extended till next date of listening list accordingly on 9/9. It will be it will last.
CD
CD not received. Where?
Doctor will call for the CD.
38 where? 36 we have already passed the order. 36 no one appeared. You have submitted that CD not received, but they were on entry. So we had extended their entry until 9/9.
Doctor,
Now in 38. 38
No.
you are appearing.
13 maybe. Initially, I am the petitioner, my lord, and
Huh?
annexer 1 is the SR, my lord.
38 full. Yes, what you have submitted?
Here the fact is this, my lord, and some persons are loitering near the, my lord, ATM, my lord, in Golpra, and so police, my lord, arrested one of them and others are freed away. Subsequently, the arrested person mentioned my name also, my lord, that I am also involved in this case. Actually, my fact is that I am a driver, my lord, of truck. And the person who mentioned my name, he was
61 means?
My lord.
61 is also there. Case is registered under 61.
61, 62. Give me a question. 61 to 62 also, my lord, and 3095.
Mine.
attempt to commit robbery. But nothing was found from the petitioner, my lord. Nothing is there, my lord. Only he was the driver of a truck, my lord. And the person who is the main person arrested, he mentioned my name as because I was his driver, my lord, at the relevant point of time. So, my lord, I allow
61, one, this is the criminal conspiracy.
My
it is totally suspicion and nothing is found. my lord. And petitioner has been children and wife, my lord, only. Annexer 1 by Azhar page 10, the lordship mechanism.
Attempted to commit robbery.
Robbery.
This is the allegation.
61 my lord to 309 attempt to commit robbery. Attempt to
There
commit.
was a conspiracy and attempt to commit.
Yes.
Yes.
My lord, I have received the case diary, my lord. From the case diary, it reveals that, my lord, one person is, my lord, caught red-handed, my lord. His name was, my lord, Kunduru Bira Reddy, my lord. He was from Telangana, my lord. He was from Telangana, my lord. What happened, my lord? They are loitering in the, my lord, near the ATM, my lord. And when police person came there, my lord, they have fled away, my lord. One person caught red-handed, that was presently, my lord, Kunduru Bira Reddy, my lord. And from him, my lord, it was recovered, my lord, one gas cutter, implement along with pipe, my lord, one small size gas cylinder, one oxygen cylinder, 5 so, one screwdriver, one Paparia company wrench, cello wrench, one plus red color, 2 iron crowbars, this one everyday
Miss
powder and
powder.
one spray, my lord, spray. All of them, they are, my lord, ready for the, my lord, offense. One glamour motor, 2 numbers of black glass, white frame, my lord. And from the statement, what was arrested, my lord, accused person Kunduru Bira Reddy, my lord. From his statement, my lord, it reveals that he is also, my lord, one of the person, my lord, who involved in this, my lord, offense, my lord.
They made a conspiracy with an attempt to commit robbery.
My lord, my lord. All
Attempt
of
to
them are
commit, but
fully,
there is nothing, my lord, only suspicion that they will commit.
all of them are fully
If we go to
prepared.
the near the bank, my
One
lord, then
police
it will be
person came, my
problem for
lord,
us.
straight away, my lord.
My lord, yes.
And he is from Telangana, my lord. Then he taken some local person, my lord, for that offense, my lord, for committing the robbery, my lord, in the ATM, my lord.
Oh, they were full cooperation.
My lord,
Sonwar and Makbul.
my lord.
1,000 they were restricted, taking all the evidence.
But I am local. So
If the police did not take, my lord, the offense will committed, my lord, they have fully prepared, my lord. All of them, my lord.
Fully prepared.
Fully prepared. Gas cylinder.
the reason I have an access to my driving license, my lord, is because I was his driver earlier. So I am not doing his job, my lord. So, my lord, my name has been.
No, that
mentioned.
is the statement, my lord. How they are
So you
prepared,
were
my lord.
driver.
He also
I was
taken
there.
one second-hand
Once.
vehicle, my lord, for that, to carrying
For
that
that carrying
materials, my lord.
I was a
Carrying that materials.
heavy vehicles driver, my lord. Correct.
Part Mr. Leadership, Ilan constituted petitioner. Part Mr. Sharma, Ilan petition, paying on behalf of state. Also heard Mr. B. Sharma, Ilan petition, paying on behalf of state. This is an application under section 7 in connection with CD receipt, where it's the same, part of same. It is submitted by Mr. Rashid that the present accused petitioner is innocent and he is no way connected in the alleged offense. However, as he was found near the ATM ATM counter. He was suspected in mm, mm, he had police had the suspicion on him, and for which the present petition has been filed seeking anticipatory. However, he is ready and willing to cooperate with I in further investigation of this case if it is granted with the privilege. Next one, Mr. Sharma, the learned PP submitted in this regard that the present accused petitioner is very much involved in the alleged offense, and with a conspiracy, the present accused petitioner along with the others were made an attempt to commit robbery, and to that aspect, the present petitioner also, filing petitioner along with the others also brought some materials for committing robbery, which were accordingly seized by police during investigation. Mr. Sharma accordingly submitted that this is not at all of the case to extend the privilege of pre-arrest bail to the present petition. Expera, considering the submission made by the and on basis of and considering the materials available in the case diary, incriminating materials available in the case diary, and gravity of the offense, I find that this is not a fit case to extend the privilege of pre-arrest bail. The present petition accordingly this seems consistent. Your petition stands rejected.
Hello, one person.
Matters between.
One prayer, Milord, sorry, Milord, on item 43, Milord, CD was called for, CD has not come, so Milord, next date, mechanically.
My lord, 39 will be day after tomorrow.